Cannabis bill. Maybe before we proceed, I know that there are people who would want to make apologies. Honorable Swart, are you still going to the Chief Whips Forum?
Yes, Chair. Thank you so much. Good morning. Good morning to my colleagues and all the participants. Please accept my apologies. I will be attending the Chief Whips Forum this morning. Thank you, Chair.
Thank you. Thank you very much, Honorable Swart. Any other apologies? Committee Secretary, are there any apologies?
Good morning, Chair. There are no apologies from our side.
No, thank you very much. Maybe we can proceed.
Mr. Chair,
Recording
Mr. Chair,
in progress.
Sorry,
Honorable
I can't seem
Brigadier.
to raise my hand for some reason.
Okay.
I'm in the same venue as the Honourable Engelbrecht, and so to save my battery, I'm going to join with his device. So I'm going to log off on mine, but I am present.
Okay, thank you, Honorable Breitenbach, for alerting
Thank you.
us. Thank you very much. Members, late yesterday, we received correspondence from Doctors for Life. They indicated that they would like to be added as one of the presenters for today. We have duly agreed based on the discussions we had yesterday. So they will be presenting, they'll be the last ones to present today. So Doctors for Life will be participating in our public hearings. Committee Secretary, can you call the Rastafari National Council? Please, everybody note that presenters have 10 minutes to make their presentations, which will be followed by questions from members of Parliament or the Department of Justice. Answers and in-fact questions and comments from the Justice Portfolio Committee and from the members of the department. Those are the people who are allowed to speak and ask questions. It's the presenter, the members of Parliament, and the Department of Justice, the drafters. Thank you very much. Let's have the first speaker.
Chairperson, the
Yes.
first organization doesn't seem to be on the platform yet, but I think Mr. Van Zyl, the second one, is on the platform. Maybe we can start with him.
Okay, so if the Rastafari National Council joins later, you will alert us. Let's have Mr. 18 Van Zyl.
Good morning. Can you hear me?
How are you, sir?
I'm fine, thank you. And yourself?
Thank you very much. Sorry for hijacking you. You have 10 minutes. You can start with your presentation.
Okay, thank you. I request to share my screen so I can put the presentation on screen for everybody to see. Sorry, did you hear my request?
Yes, you can do that. Can you assist with? Can you assist him to be able to share his screen?
Yes, you can go ahead.
Okay. Let's see.
Your time starts now.
Just how do I make this? There we go. Okay, you can see my screen.
Yes, we can see.
Okay, thank you. My name is Etienne van Zyl, and I'm a social anthropologist. I've been studying the cannabis policy context in South Africa for the past 3 years. I've been engaging with a broad intersection of stakeholders, anywhere from people who sell cannabis on street corners, matchboxes, all the way through to licensed producers. So my area of focus was in both the illicit and licit, or informal and formalized cannabis economy thus far. So the key focuses for my presentation will be on comments, including the including industrial cannabis or hemp in the Cannabis for Private Purposes Bill, problematic terminology, non-evidence-based policy, cannabis terroir, which is an interesting concept to understand what cannabis actually is, because there seems to be some sort of confusion around that still. And then unlocking our landrace cannabis and harm reduction. So these will all focus around the hemp clauses specifically, although they might speak to other parts of the bill, but because obviously, you know, the bill is an interactive document where clauses do interact with one another. Point number one, inclusion of industrial cannabis or hemp in the Cannabis for Private Purposes Bill is nonsensical. The Cannabis for Private Purposes Bill is supposed to deal with private use only, not industrial or commercial purposes. Cannabis for industrial and commercial purposes should fall to the DTIC and DELRAD, as cannabis is an agricultural crop or commodity. The bill should not be used as a legal instrument to fix inherent issues in the Plant Improvement Act. South Africa has no obligation to regulate industrial cannabis as per perceived international treaty obligations, as is frequently cited by the Department of Justice, Department of Health, and SAPRA. Therefore, industrial cannabis or hemp does not belong in the Cannabis for Private Purposes Bill. Just to point out that in the Single Convention on Narcotic Drugs of 1961, Article 28, Part 2, stipulates that this convention shall not apply to the cultivation of the cannabis plant exclusively for industrial purposes, fiber and seed, or horticultural purposes. So that sort of clarifies, you know, to an extent, the legal confusion that exists and that is used in rhetoric to defend or posit why it's not possible to open up industrial cannabis for the wider South African community. Problematic terminology, industrial cannabis is a better term, rather not hemp. So there's reasons for this. There's actually no such thing as hemp. Only cannabis used for industrial purposes or industrial cannabis. Obviously, there's other purposes cannabis can be used for as well. But in this case, we're obviously dealing with the hemp clauses. So I'm just addressing the insufficient lexicon that is used in the bill, you know, to help clarify some of the issues as well. While the Portfolio Committee insists on citing international treaty obligations in terms of regulating cannabis, it fails to use the standard international terminology. So the Single Convention of 1961 uses the terms industrial cannabis or cannabis for industrial purposes, not hemp. So I would advise to revise this terminology. Moreover, if the term industrial cannabis is adopted, we may be better positioned to unlock the social and economic benefits of the plant. So the non-evidence-based policy bit. In the bill, Chapter 1 definition of hemp says hemp means a plant of the genus cannabis which A, has a concentration of THC in the leaves and flowering heads that does not exceed the percentage as may be prescribed in terms of unspecified, and B, is cultivated under authority of a law that regulates its cultivation. So I'm assuming this still needs to be filled in. I would like some feedback just on what these percentages are now. I know at some point it was set at 2%. This is unclear, and we need to know this if we're going to you know, give comments on this and guide Parliament. So there is no reason to have arbitrary THC limits as well, just to speak to the cannabinoid contents. There's no legal or scientific backing for regulating industrial cannabis in terms of its THC levels. It should be regulated by its end use at the point of processing. And standard procedures exist for this already. This will allow for better whole plant use approaches, which means we can get more from the plant and enable more communities to participate equitably. The United Nations Conference on Trade and Development and the International Drug Control Conventions do not define industrial cannabis by THC percentages. If you go read those documents, you will find no reference like that. In fact, they note that there is no consensual taxonomic phylogenetic classification for industrial cannabis. We've heard this yesterday, and we've heard it in many, many parliamentary presentations by the public before. And this needs to be heeded in order to, again, unlock this in an equitable manner. Any industrial cannabis left to go feral will likely see an increase in its THC level as an adaptive and protective measure against pests and climatic changes. Basically, any hemp will magically turn into cannabis over time, because there is no difference between the two. It's simply what you are going to use it for that determines that function. So just to touch a bit on cannabis terroir, which is an interesting concept that helps to understand the differences between case uses for cannabis. So terroir is a complex concept according to which the typicity of a plant product is determined by both its natural and cultural environments, and that a landrace is a domesticated variety of a plant or animal species that, due to isolation, has adapted to its natural and cultural environments. In more complex terms, one can say that a terroir is the expression of how non-genetic factors such as environmental and cultural factors impact on the genotype, as well as the phenotypic plasticity of a given cultivar. Most especially in the long run, a landrace, and of which we have a couple in this country. So just to explain this in a bit more detail, you have typicity here in the middle, right? And it's affected by three different factors. So the one is physical and biological. So this is, an environment. So this is soil, climate, relief, surrounding livestock, and other living elements. Collective production knowledge, IKS, you can call that. So that includes social, economic, political, cultural, technical characteristics developed over time as you interact with the plant and understand it for the use purposes that you intend to use it for. And then crop specificity and diversity. So species and genetic diversity, such as landraces, heirlooms, hybrids, all of these things come together to create terroir, which is unique to South Africa. In our case, you get many, many different landraces in different countries, but we have a very specific one that's adapted over centuries, and specifically an intensive century of farming. So the takeaway from this is that we have our own land races, which have been produced by environmental and cultural market dynamics over more than a century. Land races are more sustainable than other varieties since they have been selected for local pest and drought resistance, as well as their preferred effects for use in traditional medicine and herbal preparations. So there's a deep cultural element to this, right? Livelihoods and traditions that rely on local land races as a resource are at great risk should the bill's proposed regulations on industrial cannabis be enacted.
You are left with 2 minutes.
Okay, point number 5. Unlocking the potentials of our land-raised cannabis. So if we change regulations accordingly, we can enable rural communities to utilize an economic resource and knowledge base, IKS, which already exists, and they have access to this. So it will significantly reduce costs to enable participation for rural farmers in the industrial cannabis sector, sustain and potentially bolster existing value chains based on existing community values and relationships, legitimize and sustain established cultural practices, reliant on land-raised cannabis genetics. Some traditional healers, for example, only use certain parts of the cannabis plant, and many of them dislike unknown and foreign varieties of cannabis that have not been established or cultivated for their traditional medicinal practices. So at a very basic level, enabling legislation will allow farmers to make additional income by trading leftover biomass, which can be used as energy, livestock, feed for livestock, compost, beneficiated into many value-add products, such as building materials, hemp bricks, or aggregated into cell fluid extraction for other industry. So just a figure here, what we've already seen, according to recent research heard from a portion of rural farmers that are cultivating cannabis, can already amass to 451 million rand if we utilize it properly, and that would mean a lot for those communities. In terms of harm reduction, the Portfolio Committee has a unique opportunity to leverage the bill as a harm reduction tool if the socioeconomic dynamics of harm reduction is properly understood. Harm reduction does not mean to keep the consumer from their preferred substance, but rather to make pathways available that lead to safer sources, better education, and treatment options if needed, which are free from continued criminalization, stigmatization, and marginalization. So instead of intensifying criminalization measures through prison sentences in an attempt to limit cultivation activities around cannabis, rather develop pathways to enable safe consumption and honest drug education if scale of cultivation is a concern. Otherwise, it artificially closes off the opportunities for private individuals to use industrial cannabis. I would actually like to go into my next slide, and maybe I'll come back to this if I have time. I just want to show the relative social harm of cannabis, right? So consider that this is statistics from the SAPS, right? Showing contact crime in liquor and drug-related offenses. Now, the red bits here show all drugs lumped together. That's cannabis, methamphetamine, cocaine, heroin, all kinds of street drugs, right? Compared to alcohol, which is the blue bar. Now, if this doesn't show you that, at least in terms of criminogenic activity elicited by the use of drugs, alcohol far outweighs the harms. And I still don't see why we're approaching cannabis not at least in a like manner, even though regulations should be far more relaxed for it. The evidence shows this is from 2021.
Thank you very much.
Financial year.
Thank you very much, Mr. Van Zyl. Your time is up.
Okay, right. Any questions? I'm available for
yes.
That's it.
Yes, but we do have the presentation, so we still go through. Members go through the presentation. Members, are there any questions or comments?
Chair Swart.
Okay, I have Honorable Swart and Honorable Yako in that order.
Thank you, Chair. I appreciate the presentation and the possible benefits that industrial cannabis and hemp in particular and others can bring to the nation. I just wanted a comment to ask the presenter, Mr. Van Zyl, about the THC limits on industrial cannabis, particularly in the hemp context. And it appears that what is intended is a European restriction. And we know that South Africa has got different climatic conditions. We know the challenges that, for example, the Amapondos have experienced. And we also know, for example, that the biomass often has to be imported, hemp cannabis for industrial purposes. We know there was a hotel built in Cape Town where local products could not be used because of the legal constraints. And the hemp that was used was imported to the detriment of our local industries. I'd like you just to comment on, firstly, you indicate that there shouldn't be a prescribed THC limit, but secondly, on what is intended, the limit on what is intended, given the South African conditions. Thank you so much.
Thank you.
Yes, thank you for
okay, let's just take another question before you answer. Mr. Van Zyl, thank you very much for your understanding. Honorable Yako.
Thank you very much, Chair. It's not really a question, it's just a comment to appreciate this presentation. It's very extensive. Yeah, I think that's just it, to just say that we appreciate the work that's been put into putting this presentation together, especially highlighting how harmful alcohol is, in fact, and how it contributes to a lot of crime in this country. And that's it. That's it, Chair. Thank you very much.
Thank you very much, Honorable Yako. Mr. Van Zyl.
Thank you. Yes, first I would like to just apologize for rushing through the presentation like that, but as you could obviously see, there was a lot that I wanted to get across with in a very limited time span. So to answer Honorable Swart's question, I would just like to clarify what you mean by the sort of local or my intention in terms of local uses, but let me first answer how I understand it, which is to say that THC limits are arbitrary in the sense that at the point of processing, we can actually remove, or we can divide the plant into different streams, right? For use, so you separate the flower and the seed and the stalks. And the stalks get beneficiated, for example, into herd and textile and whatever use cases you can use a very specific cannabis cultivar for, which differs from cultivar to cultivar depending on where in the world you go, which is why we have so-called hemp strains as well. Which does not mean that our land races are inferior to those strains. In fact, they are, as I mentioned, very well adapted. Yeah, THC should not be an issue because, firstly, and this is something that a lot of people don't know, that cannabis as it stands in the field actually contains very little, if any, THC in the plant. So if you go up to it and you pick off a bud and you put it in your mouth and you eat it, nothing is going to happen, right? It needs to go through a process, much like feedstock for alcohol. If you take grain or potatoes or whatever, it needs to be turned into alcohol, right? So the same, in a similar way, not exactly the same, but cannabis flower needs to go through a process called decarboxylation, right? Which makes it takes the tetrahydrocannabinolic acid, right? And it removes the acid part through decarboxylation and then makes it into an active compound that can then, have psychoactive and psychotropic effects. So again, from that point of view, there's no real harm, and all the, fences and what, all the onerous aspects that the Plant Improvement Act and the hemp permits require are actually nonsensical, and it's just another barrier to entry for rural farmers. I hope that answers your question. Please, do elaborate if there's anything else I can add.
Thank you very much, Honorable Maseko Jela.
Thank you very much, Chair, and good morning to colleagues and also Mr. Van Zyl. The only question, in actual fact, Chair, let me just start with the view that I think the department will still have to give us information in terms of the scientific views about this, how the approach that we have taken in coming up with this bill in future. But I also would want to know from Mr. Van Zyl as to there are different views in terms of the issue of coming up with this bill. For example, there are those who are saying there's no need for this bill. There are those who are saying we must have it, but we must tweak it there and there in order to be in line with the Constitution. Some are saying the bill is just unconstitutional. So I would like to hear your view in terms of that. Thank you, Chair.
Well, I mean, I do feel that there is need for a bill, but at the same time, I feel that there are a number of unconstitutional elements to the bill, which have already been addressed in previous parliamentary meetings on this and yesterday's meetings as well. So I would add that that is something that we really need to take the time and look at carefully if we want to open up this industry and make it equitable and just, because there's so many communities that have historically suffered violence at the hands of, firstly, the apartheid government and continued into, our democratic system. It's criminal that that's happened, right? So if we want to enact restorative justice, we definitely need to consider how we approach this. And yesterday, there was a mention of, we're in the sixth, towards the end of the sixth Parliament at the moment, and that this bill should rather be enacted before the seventh. I mean, I can see that, politically why that would be necessary or wanted, especially in terms of the legacy that you yourself mentioned, Mrs. Jelle. But I think if we rush into that, we are going to potentially create more harm than we're going to actually enable equitable participation, because we need to look at this from firstly from a harm reduction side and from a human rights perspective. Key, if we take a human rights perspective to cannabis, I think we can actually eliminate all the unconstitutional elements in the bill if we just systematically go through that and keep the private purposes, cannabis for private purposes bill for just that, cannabis for private purposes. Where it falls to commercial activities, I would say the relevant departments like the Department of Trade, Industry and Competition, for example, need to deal with that bit, which I understand they are to a degree. But again, that obviously has implications for the bill in its current and future form. Something I don't think the public is necessarily aware of, that there's a lot of machinery happening in the background, turning as this, excuse my well, lack of a better term, but this political theater almost on some level, continues, whereas those processes will actually in a hierarchical way affect what the bill can actually do, because if there's a need from the Department of Trade or the Department of Health or the Department of Agriculture, for example, to change anything that is hampering this sector in the bill, it's going to have to be revised, and it's going to take up your time, members of parliament and portfolio committee, and also taxpayer money, and I can tell you from what I know from my research that if the bill gets enacted in its current form, unfortunately, there will be constitutional challenges on this. There's already plans in the making for that. So it's not going to go unchallenged. And I think that is something that is key to consider in this process. So rather than trying to push it through in the 6th Parliament, I would advise that you actually take a human rights approach and revise everything that, consider carefully the input that's been given by various members of the public, and do this in a manner that serves our democracy and serves human rights.
Thank you very much, Mr. Van Zyl. Thank you for the input and for preparing the document. Thank you very much.
Yeah, thank you for your time. I appreciate it.
Thank you very much.
Are there any more questions?
I know that was the last question.
Okay, perfect. Thank you.
Thank you very much. Marijuana Board of South Africa. Honorable Jele, can you take down your hand?
Greetings, Chair.
Apologies, Chair.
Thank you. Thank you. Greetings, how are you?
You can hear me, Chair?
Yes, we can hear you, but we can't see you.
Yes, Chair. Oh, the Chair wants to see me.
Maybe let's just proceed. Just proceed.
Can you see me, Chair?
Yes, we can see you now. We can see you. Maybe for the purposes of bandwidth, you can switch it off now.
Okay, thank you. Let me thank all the people present and thank the department for being here, for bringing justice to the people. As Marijuana Board is for the second time we are here. We were here previously to make a submission. And we have had all the submission from our colleagues yesterday, and we are not going to repeat what they said because the presentation were as we find it as we go around the country consulting. But one that I need to say from yesterday, Chair, is that let me acknowledge what the Rastafari National Council said on the issue of hemp, because on the issue of hemp, we have a serious challenge, Chair. The challenge is government does not know how much is the THC level that must be put on hemp. And that is a serious challenge. So they are proposing that we must look at 5% THC, but some of our land rates, they go up to 8%. So to add in what the previous speaker has said, Mr. Adley, is to say, let's look at our land races that are low THC and use them as. And again, Chair, there is no difference between cannabis and hemp. It's just a political statement or a legislative statement. So this is one big plant and we must stop separating it or dividing it. We must keep the plant as is. We must stop this racism that we are doing. And also, we must stop this femicide that we are doing, because when we hate the THC plant, we hate the female plant. And now that thing is GBV. So those were the things that I wanted to note from yesterday, Chair. And to say for today, we needed to advance ourselves in terms of the discussion and make sure that these discussions are fruitful for all community of interest, so that those who hate cannabis do not have an opportunity to thrive because government is failing. So as marijuana board, we are proposing that we need to adopt this committee must adopt Marijuana Board of South Africa as the national service provider in cannabis. One board, one nation. Because that's the only way to streamline our economic activity. As the board, we tried the alcohol way, like using a similar model that the alcohol are using to regulate our people. But when we go to some police station, some commissioners refuse to sign the document that the dealer is declaring to say, me, I'm a dealer of ganja. I service people with ganja. So the time that we are in, Chairperson, is called the legalization time. We have moved from a point of decriminalization. Now we are at the point of legalization. So at the point of legalization, we must legalize. We must set up institute. Government officials must stop making businesses for themselves. They must give business to communities of interest. We must set up institute such as your Marijuana Board. It must be nationalized. You must have your National Cannabis Development Council, which was also set up and which has done a lot of hemp permits and hemp awareness in the past. A lot of people that have this hemp permits, Chair, it is because of the work of the Cannabis Development Council that went around the country to do what we call permit readiness. And indeed, most of the people who have permits in our country, they have it because of such organization. But the challenge was one, the seeds. The seeds of hemp were nowhere to be found. And we were told that there was Lumna 1 in South Africa and Lumna 2. We requested this committee to clarify us about the research that was done on hemp by the National Hemp Foundation in South Africa, and where are those seeds so that those seeds can be used. We are also saying, Chairperson, it is high time that our politicians, they don't walk zigzag. Like when we go to government institutions in Gauteng here and other provinces, other politicians, they chase us from the offices. Other director generals tell us, advises us that we must go to the streets and strike. When we tell them we are not here to strike. The time to strike is finished. The time that we are in is called legalization. So because we are dealing with the issue of legalization, we are saying Parliament must not only look into hemp, the entire species, what hemp can do, even the so-called dacha can do. So the entire species in its totality, whether male or female, whether short or tall, whether big or small, whether big leaves or small leaves, we must love it as is. But also to say the previous speaker who has spoke here has spoke good in terms of what will this foreign alien plants will do to us, as South Africa has already opened floodgates for foreign products of hemp that we have in Discam, clicks, and so on. What is the negative impact of this proliferation of foreign hemp products when we do not respect the products that are done here locally? So we see that government's department, they are not working with us. Also, the Department of Trade and Industry, we did go and try to advise them that as a board we could help them so that we could fast track the economy at the ground to make sure that people understand this hemp industry. But they never opened doors for us. So I'm surprised that why do we continue giving information to you while ourselves, our community don't benefit from you? And lastly, Chair, we won't be coming to this meeting for as long as there is no moratorium on cannabis arrest. We can't trust the politicians when they tell us that they will give us expungement of cases when they are busy creating more cases as we speak. I would like to say to you, Chairperson, the CRL Commission has ruled in 2012 that Parliament must make a moratorium on cannabis arrest. And Parliament has delinquently failed to respect the Chapter 9 institution from that day to date. The same way that Parliament has delinquently failed to comply with Justice Zondo's judgment on cannabis, that by this time we could have the law.
You're left with 2 minutes.
Yes, Chair. I'm saying in the midst of whatever that is happening, Chair, our challenge is one. And that challenge is we are still arrested as marijuana users. So my fellow brothers in the Eastern Cape there, they did at least 1 minute to raise their concerns, because they too, they have a word to share to the community. What they say to you, Chair, they say they encourage that government must free everyone from prisons who have been convicted for marijuana and charged. And then they speak for the expungement and the moratoria. They say we must abolish this cannabis licensing for members who are previously disadvantaged. They say we must eliminate the unaffordable administration fee, especially in SAPRA. They say Parliament must encourage formation of community-based to form seed banks of indigenous land raise and multiplication, and recognize the IKS and integration plan into your Highland. So they say it is time for the legal market of cannabis. It's time for you to officialize the Sneyman. It's time for the Sneyman to be happy that once a criminal, today I'm a businessman. Chairperson, I'd like to thank you very much for your time and the audience that you have given us. As Marijuana Board, we say, ai khutle naha le matekwana yona ai ne pula le fatshe le betala ta oha.
Thank you very much, Mr. Kuno. Any questions, members? Thank you very much. Let's proceed to the next presenter.
No, Chair, I was, sorry.
Mamutele?
Sorry, Chair, I was just struggling to get to my, where I raise my hand. Sorry for that, Chair. It's just that I wanted to find out, Mr. Kuno raised so many issues, Chair, that I think most of them also, they need attention. So I think the committee in our sitting, when we deliberate on this issue, the department must assist us to separate those issues, and those issues must get attention, Chair. If they don't belong here in this committee, maybe in terms of us having to work with this, the bill. If those issues, the allegations that Mr. Kunong is talking about, Chair, they are really true. That, for example, that there are people who are still getting arrested at this juncture, Chair, at this moment where we are, whilst we are dealing with all these issues, and the police are continuing arresting people, for example, and also the issue of coming up with those structures and all those things. So I think, Chair, those issues must be noted and they must be dealt with accordingly, and so that we get some satisfaction from our community. We don't deal with many issues that are not supposed to be belonging here. So the department must assist us, Chair, to sift and check which one belongs to with us, and then so that we can be able to, in our discussion, Chair, consider them. So I wanted to make that comment, Chair, so that we eliminate some of the things which need some attention at some point in future. Thank you, Chair.
Thank you very much. I think the department has taken note of the issues raised. I don't think that there was a question directed at Mr.
There
Kuno.
was a question.
Hello?
There was a question on the police and the arrest. And
Okay.
I would like to confirm to Mamjele. Mamjele, we are still arrested. We are still arrested. West Part, the Rastafari people are a target. Currently in Gauteng, there is a new brigade of police who wear green. As we speak, those police, they violate the rights of the Rastas. They arrested the priest, they don't care. They go to traditional healers, they don't care, they do as they please. And when we go to court, the court does not want to see this case. Almost 12 cases were struck out of roll for dealing with Taha in Steve Chwet, the magistrate in Gauteng. So that's why we are asking this committee, Mamjele Ralekopa, to rekopa moratorium on the cannabis arrest. Otherwise, next time when you call us, we are telling you we're not gonna come. Because why must we be in a Codesa while our people are murdered, while our people are arrested? Why must be in a Codesa when people are behaving worse than Terre Blanche, worse than all the Vervoorts and all the people who did not want this democratic state? It's the same feeling that we are feeling as the Black people. It's the same feeling we are feeling as the Rastafari people, as the community. We are under a serious attack. We can't sleep with our children. And that causes more harm to our family.
Thank you very much, Mr. Kuno. Thank you for the input.
Chairperson?
Yes.
The Rastafari National Council is ready. I don't know, can you go back to them?
Yes, let me finish. Let me first finish with Mr. Kuno.
Okay.
Thank you very much, Mr. Kuno, for making the effort to make your input to this bill.
And how will we know about the follow-ups that Memjele requested? How will we know from our side what is sifted and what is not sifted? What needs attention?
Our meetings are public, so even the deliberations would be public. You would know how are we discussing and which decisions have we reached before the bill goes to the National Assembly. All our meetings are televised.
Thanks for the opportunity. Thanks.
Thank you very much. Now let's go to the Rastafari National Council. Rastafari National Council. You have 10 minutes.
Greetings, Rastafari. Give thanks, Honorable Chair. I hope you can hear me very well from your side.
We can see you and we can hear you.
Rastafari, give thanks, my Lord. Give thanks. I also greet all the honorable members of the Portfolio Committee and everyone who's here. Without a waste of time, my name is Dr. Motel Guestiri. I'm normally known as Ras Foundation. I'm the chair of the Rastafari Nation Council. I hope you can also see my presentation there.
Yes, we can see it.
I'm going to try and run quickly over it. I'm doing it on behalf of the Rastafari Nation Council. I have a presentation outline. You see there's an introduction, and I will also come up with a conclusion. And there is also content to this presentation. First of all, I would like to say that the Rastafari Nation Council, we represent all the Rastafari organizations in South Africa. And one of our most important things with this particular issue is the Rastafari Cannabis Sacrament, which we also want to use with accordance to our indigenous knowledge systems rights to share the commercial benefits of legal cannabis to redress the injustices of the past with regard to the IKS policy and the IKS Act of 13 of 2019. You can see I have a booklet here of the IKS policy, which looks at these issues of how we can redress these issues. So as a Rastafari Nation Council, I think our submission, it looks and it actually is based on some of these legal frameworks. As South Africa, we're one of the country with a policy and legal framework on IKS to show the commercial benefits around this. So as a global Rastafari community, we know that we've been the champions of cannabis, especially with regard to legalization. We have read also, Raskuno also has spoken about that. So we are also focusing on the wealth of indigenous knowledge. You know that there's also a case of 2002 by Rasgareth Prince, the Constitutional Court, which found also to declare that the Rastafari deserve to be also protected and also to ensure that even our religion is also recognized. We also have the CRL Commission that also came up with its own report. But yet to date, as members also of the Rasta community, we realize there's a lot of harassment. We still get harassed, we still get arrested. Even myself, I think during this week, I was arrested by the police for possession of cannabis. I think this must come to an end because we cannot live in this country and still be treated as if we are criminals. So as the RNC NEC, we think that in South Africa, we need to be given our religious dignity. Also, with regard to representation, we represent diverse voices of Rasta in South Africa, but there are also other organizations and mansions which also put their presentation, including the Zion, Rastafari, and other organizations mentioned here. Quickly, on terms of the comments with regard to provision of hemp commercialization, we totally reject the use of the term hemp because as Rasta, we deal with ganja. So we prefer the use of local low THC cultivars of indigenous ganja land races. And we also want to ensure that we cater for those who want to explore low THC dagga to create comparable dagga create as input of low costing. And also conditions of hemp permits must not create high barriers of entry for indigenous farmers from IKS communities. And on slide number 3, RMC comments on special measures to accommodate cannabis for cultural and religious community. We realize also that as a Rastafari church, we also want to have full authority to self-regulate the cannabis sacrament because ganja is a sacrament for us as a Rasta community. So we can have seed breeding, cultivation, and all those other important things for religious and spiritual observance. And we also want to ensure that we supply cannabis sacrament from one Rasta community to another across the province and nation. And we are also going to create a database of bona fide Rastafari adults who are also able to use this for the purposes of religious and cultural. We also have the Ancient Council of Rastafari Elders, who we're also going to use to monitor and to enforce compliance and to mitigate the unintended consequences and also ensure legal cannabis, especially with respect to children. With comments on RNC, which were made previously, we also realized that we also totally look for the legalization of cultivation of cannabis crops only to regulate for commercialization. And as the Rastafari also, we also don't want to see the concept Rastafarian being used in these bills because we're not Rastafarians, we are Rastafari people. So we want these terms not to apply. Also, we want to work on the public awareness, raising on safe ways of consuming cannabis to render all those health benefits. And we also want to fight against the exclusion of Rasta in all this illegal ganja farming and distributors in the legal cannabis industry. Going forward, we also want to ensure that there is accreditation and training and human capacity building, and also on issues of recognition of prior learning and integrated community skills transfer. We also want to ensure that there's also streamlining of legislature to gather all departments that are involved in the cannabis industry. And we also want to demand a moratorium and on all cannabis arrests, harassment, abuse. I think Rastafari and other members of the Rastafari committee has also spoke about this one, including the expungement of criminal cases, and also to engage with community facilitators and community researchers, including also institutions of higher learning, which could also be part and parcel of bringing research, integrated research, and also bringing indigenous research methodologies, because for us, the legal framework is indigenous knowledge systems. In conclusion, our concerns are not just for the Rastafari community, but for all the indigenous communities, because we also work with the traditional healers and also the traditional leaders. And we also want to appeal to the Portfolio Committee on Justice and Correctional Services to ensure that the proper community public consultation, where there is also direct consultation with religious and cultural communities. With those few words, my leader and all to all members of the parliament, I give thanks. Siyabonga, Rialeboha, Ndoleboha, Mkensile, Enkosi, Dangi, thank you very much. If there are any other questions that you would like us to maybe bring forward with clarity, I will do that, because I'm also with my Secretary General here, Dr. Tandeka, who's also the Queen of Ganja in South Africa, will also provide more clarity. And we hope, Honorable Chairperson, one day will be invited to engage fully on these issues, because we also want to have a hub of Ganja where we can bring all these research institutions, because also myself, I'm also a director of Indigenous Knowledge Systems Center at Northwest University. We work with government departments like Department of Science and Innovation, the Innovation Hub. We also have a consortium of 5 universities in South Africa, UKZN, Venda, Limpopo, UNISA, and ourselves. So we want to do large commercial research on Ganja, so we can also show the commercial benefits and the medical benefits. So as the RNC, I think we are the voice of all the Rastafari communities in South Africa, and we want to ensure that government listens to us, because we can make a very important inputs to ensuring that we deliver poverty alleviation and job creation, and also what we call economic empowerment. I give thanks, Chairperson, for the opportunity. Rastafari, give thanks.
No, thank you very much, members. Any questions, comments? Honorable Masego Chele.
Thank you very much, Chair. And thank you very much. I didn't get the name. Okay, I see that one. Mr. Dr. Matthew Huiziwe. Thank you very much for the presentation. I only have one question, because, Chair, this question keeps on coming about the restrictions on the percentages on the THC. They are saying, a doctor says that 0.2% is restriction is unrealistic. Is talking about the Southern Hemisphere. There's a line there that he mentioned. And also, Chair, I keep on hearing some, they are referring to 5%, some 8%. What is really the percentage that they would love to see or have on this matter, Chair? Thank you very much.
Give thanks, Honorable. I'm going to allow one of my specialists, because we work as a team in this Ganja project, Dr. Tandeke Kunene, the Ganja Queen of South Africa, to respond on this issue quickly. Thank you very much.
Oh, thank you, Dr. Motera. Thank you to everyone who's here. In terms of the unrealistic, is less than 0.2% THC levels, when we were doing research for about 14 years with the ARC, we found that the Southern Hemisphere percentages do not go under 2%. That was what our findings was over a 14-year study, that in Southern hemisphere, maybe a cultivar from the West, from France, Northern Hemisphere, comes here, it's labeled 0.2%. We plant it, second year, third year, it has become maybe 1%, 2%. In fact, the legalization of hemp in South Africa was based on under 2% results, because most of the time we could not get it lower than 0.2%. However, in other countries like in Australia, even in the south part of China, they allow between 0.2% and up to about maybe 5%. That is what would be like a dragging effect. We have strains here in South Africa that have got 4%. Some of them have got a 7%, but their male part will be under a 5%. So I think scientifically, if you looked at local indigenous cultivars, you will be able to get under 5%. That will not get you high or anything like that. But if you specify 0.2%, the possibility is that almost everybody who's growing hemp will not be able to comply. Thank you.
Thank you very much.
Chair, can I make a follow-up? So what is their preference? Thank you, Chair, if I may ask.
Yeah, I think 5%, as you can hear, my honorable sister, is a preferred percentage, because as you listen from one of the experts, we've been engaging in this area for a long time. So what we need here is something that actually is going to be workable, appropriate, and also, effective for us. But the Queen is also here to respond.
Can I also stress that a female plant that has got 20% THC, the male part will not have 20%, it will have about 5%. So if you say limit is 5%, it must specify that is the male part that is limited, because you find Durban poison is 22%. However, the male is 5%. And we are saying, let us use the male part. Yes, it's true what Mr. Kuno said. This is a GPP against the female plants, if you against the high THC. But if you actually limit it to 0.2%, then you are destroying the male plants of the indigenous cannabis of South Africa. Give thanks.
Yeah.
Thank you very much. Thank you, Doc, for the presentation.
And as I just said, Chair, just in conclusion, we are driven by the IKS law with regard to what we are presenting here as the Rastafari Nation Council, and also our own natural laws of how we engage with natural products. Because what we are saying here is that South Africa is the only country in this continent which have got a law like this one. So let's implement this thing, and let's ensure that the Rasta, they enjoy their IKS rights, and other communities, which include the healers and also the traditionalists. So I think in that case, let's make sure that even the parliamentarians, the politicians, they don't overlook our indigenous practices and technologies of how we can mainstream indigenous knowledge systems into this cannabis industry. I give thanks.
Thank you very much. Let's move to the next presentation by Mr. Ozinski. Mr. Ozinski. There's a background noise there. Can you try again?
Yeah, can we?
Yes.
So, good morning, Chairperson and members of the committee. Thank you for allowing me to present this morning. I just want to introduce myself quickly, Chairperson. In 1983, when I was 20 years old, I was arrested and found guilty of possessing cannabis illegally under the Medicines Control Act. I received then, after I was found guilty, I was sentenced to 60 days or 60 Rand fine, which was a lot of money in those days, as you can understand. Subsequently, I was, and at that time, I was a political activist. I worked in the mass movement, the underground. I was a commander of MK. I later became a leader of the ruling party in the Western Cape. I was a member of the provincial legislature and chief whip of the provincial legislature. I've also been a public servant, and I was for 2 years an acting DG. Chair, as I've said in my presentation, I think that government is very negligent in the way it is bringing forward this bill, the way it's responding to the Constitutional Court judgment, and the way that it is now bringing other irrelevant issues into this bill. And others, as other speakers have said this morning, people continue to be arrested for exercising their constitutional right to possess cannabis. As an example, perhaps, which the committee might be interested in March this year in George, in the Western Cape, a Rastafarian died during a police raid on his residence. And on the 21st of March, Human Rights Day, there was a march to George Police Station by the Rastafari community about that issue. And that's the seriousness which committee, government, and parliament need to take this matter. And I must say, I don't see it as someone who understands the processes of parliament and government. I don't see that seriousness. I want to start by saying that I think a large part of the problem is the Department of Justice itself, and I'm glad they're here today to see that. But the problem, Chair, for me, is the fact that the Department of Justice behaves as if we are in apartheid South Africa, and that there should be a continuation of the policies of apartheid South Africa with regard to cannabis. So when the court case that ended up in the Constitutional Court in 2018, that case was opposed by the Department of Justice, from the Magistrates Court to the High Court in the Western Cape, to the Supreme Court of Appeal in Bloemfontein, all the way to the Constitutional Court, which then gave judgment against the Department of Justice. Yet today we sit here, and it is the same Department of Justice that is providing you with drafts and advice on how to move forward. And there's no indication that they've taken that judgment into account. Let me give you a very simple example of that, which is on the issue of the amount of cannabis that a person can possess in private. This issue is raised by all the people who are commenting on the proposed bill. It is clearly unconstitutional to set a limit on the amount for personal use, because the Constitutional Court has already found on that matter. Yet the department presents you with a bill which wants to set a limit on the amount of plants or the amount of cannabis people can possess, when the court has already decided on that matter, Chairperson. So, for instance, if you hear the Constitutional Court judgment in itself, let me give you an idea on that. Paragraph 111 of the judgment on page 60, the Chief Justice says, "I think that the references to possession of cannabis for personal use or for personal consumption help to ensure that we did not have to specify the amount or quantity of cannabis that may be possessed. We only need to say that the amount may be possessed is an amount for personal consumption." So, Chair, there already the court has said very clearly to everyone, to the department and to the committee, that there is no need to set a limit on the amount that should be possessed. But the bill before you has amounts and limits. And the way I see it, with my experience, where this is going to go is that the Department of Justice is setting up the committee and government for endless court cases on this matter. which we know that you will lose. But the department refuses to change its view on that matter and many other unconstitutional things that are before you. That's just the one example I want to give. But I think we can honestly say that the department, in terms of what's before you, does not accept that people have a right to private use and does not accept that there will ever be the sale of ganja in South Africa, of marijuana in South Africa, of cannabis in South Africa. And that is at the heart of the problem I think the committee is sitting with. So, Chair, when it comes to the issue of hemp, as others have said, it has no relevance in this matter, because to legislate on the issue of private use, there's no need to then distinguish between different hemp varieties, different cannabis varieties, because people have the constitutional right to possess and use it for private use. So why would you then insert something that then is putting other limits on their constitutional rights in a bill? And so I would say, with my experience in politics and my experience in government and my experience as a citizen whose constitutional right has continuously been violated, my right to private use of cannabis, I would say to you that what is happening here is the Department of Justice is raising the hemp issue to further delay the bill, to further confuse the matter, and further create problems for the government once the bill is legislated, because they are creating the basis for continual constitutional challenge to what's in front of you. Chair, I would say to the committee, the department and government need to get serious. At this stage, 4.5 years after the Constitutional Court judgment in September 2018, we still don't see from the ruling party any policy on cannabis, hemp, or any other matter that you're dealing with. There is no policy. At the conference of the ruling party, it was not discussed. In the policy documents of the ruling party, there's not even a mention of cannabis. Yet millions of people use cannabis every month in South Africa, and most of them are breaking the law when they use cannabis and open themselves up to jail and other police action. So that's the first point. Secondly,
just 2 minutes.
Thank you, Chairperson. I'm rounding up. Maybe what I would ask the committee, because the committee has oversight over government itself, is that government does not have a policy on cannabis use. For instance, there's no white paper on cannabis, there's no green paper, there's no coordination between government departments on this matter, because we know that other government departments and even provinces are talking about other things with regard to cannabis. But the Department of Justice, the Department of Agriculture, the Department of Trade and Industry give no indication to us that there's any cohesion, that there's any one document that they agree on. And when they point to their processes, those are all processes that have taken more than 4 years, and there's no conclusion on those processes. So, Chair, my appeal to you as the committee, which only has about a year left as a committee, is to conclude this matter, which is to send the bill back, remove all the references to hemp, to instruct the Department of Justice to read the Constitutional Court judgment, and then to take the essential points of the judgment into the bill, which would then be a very simple bill. My very last point, Chairperson, is that the elephant hanging in the room is the issue of the sale of cannabis. There's a huge illegal market in South Africa that has existed for 100 years, if not more, in this. There are millions of South Africans buying and selling cannabis every month. According to Parliament, that is illegal. And you need to move very quickly to stop making us criminals by dealing with that elephant in the room. And I can assure you, to my mind, the only way forward is to deal with cannabis in the same way that you deal with cigarettes. Otherwise, the market that has persisted for so long will persist long after the ruling party is no longer there. Thank you, Chairperson, and I really appreciate this opportunity to present today, and I'm open to any questions, especially from the Department of Justice.
Thank you very much, Mr. Ozinski. Questions, members, or comments? We have Mr. Makulubete from the Department of Justice, followed by Honorable Maseko Jele, in that order.
Thank you very much, Chair, and good morning to yourself and honorable members, as well as the other participants on the platform. Thank you to the submissions made by Mr. Ozinski. And my question will obviously direct him to the judgment itself, because the judgment, the essence of the judgment was for Parliament to prescribe the amounts that will be sufficient for personal consumption, or even when it comes to the cultivation of the number of plants that are sufficient for personal consumption by an adult person. He referred to a paragraph in the judgments. However, I will also want to refer him to a paragraph in the judgment, actually two paragraphs, if I may say so. One is paragraph 80, where the court made reference to other foreign jurisdictions that had decriminalized cannabis. The judgment made a list of those, and also a list in the addendum to the judgment itself. Chair, for simplicity, I would like to read out, it's a short paragraph which says, in the jurisdictions referred to above and in others included in the addendum, different amounts have been fixed as small amounts. In the present case, like in the judge in the High Court, I will leave the determination of the amount to Parliament. I would like to hear from Mr. Ozinski. What does he make of that paragraph? Because the essence is clear that the quantities are left for Parliament to determine. And essentially, what quantities are those? They are the quantities that are sufficient for personal.
Mr. Makulubete. Mr. Makulubete. I think we have lost him, but I do think that we do have the essence of his question. I think we have taken note of the question, Mr. Ozinski. Let's go to Honorable Maseko Jele.
Thank you very much, Chair. And also, I want to thank Mr. Ozinski for this very informative presentation. You have also indicated most of the important issues that really opened one's mind in relation to this, as to what is really the bone of contention on this matter. Thank you very much. In fact, not you alone, and even others. But my Chair, I just want to hear, I think Mr. Makulubela, our department, yes. I think Mr. Makulubela, also, my comment on this is that when you assist in this, you must also consider that whatever decisions or your interpretation on this, it does not bring conflict between the committee and the community. Because we really don't want to find ourselves in the loggerhead with the community when it comes to those percentages that you are talking about. I think we are all listening, and then we have to deal with this issue so that we make sure that at least we meet each other along the way. So I will request the chair that the department resend that judgment again to the members so that we can again go through that, chair, so that we can also get more clarity as these presentations are coming daily. If I've missed that one, I would request that it should be resent, chair. Thank you.
Yes, I do think that the committee secretariat can do that. But also maybe if they can give us the link to that we can be able to download that particular judgment. Mr. Makulubete, are you back? No, he's not. Because I think
sorry, Chair. Chair, if I may interrupt, it's a civil image. I'll try to get hold of him. I was trying to search for him on the platform. He's not there. I'll make contact with him just now. So sorry for interruption, Chair.
Yes, no thanks. But I think for both the department, Mr. Ozinski, and ourselves, I think it would be better that we also reread the judgment so that we are able to distinguish between what is a ratio and what is an obiter in the judgment, so that we don't conflate them. So it would be important that we reread that particular judgment for clarity's purposes. Mr. Ozinski?
Chairperson, thank you very much, and thanks for the two responses. Chair, in terms of Mr. Makulubete's response, of course, the judgment says that Parliament must write the law. That's the role of Parliament, okay? But the question is how you go from Parliament must write the law to then putting things in the law for Parliament, which go against the general tone of the judgment. You see, of course, Parliament is sovereign, Chair, and it may write whatever it wants, as long as it's not unconstitutional. But my point is that actually Mr. Makulubete's response or question is actually reinforcing what I'm saying.
Sorry, Mr. Ozinski.
Sir?
Sorry, Mr. Ozinski. There is this Mr. Makwela. Can you unmute us? Can you mute yourself? Thank you. Sorry, you can proceed, Mr. Ozinski.
Okay, so thank you, Chairperson, for that. But so my main point is, yes, Parliament has the duty to write the law in terms of the Constitution. But it's a big jump from that point to putting limits on the amount of ganja that can be possessed, okay? What the Department of Justice needs to justify is, one, why you would put a limit and whether the limit is constitutional. Now, the difficulty the Department of Justice would have in that case is the arguments that the Chief Justice used himself. I haven't quoted all of them, but for instance, there's another point the Chief Justice makes on the amount that you can possess, which is the question of what is the use you're going to put the cannabis to. For instance, the amount of cannabis you require under your constitutional right to say smoke cannabis is different if you are going to make oil out of the cannabis. And the Chief Justice goes into some depth on that matter of the amount that might be required, which is different for different uses which you have the constitutional right to. Now, the Department of Justice and the bill before you completely ignores that issue. When you say you can only possess 6 plants, it's outrageous, because for a person who even smokes maybe once a day, if you grow 6 plants outdoor, you can only do it once a year in the growing season, and your 6 plants will be used up within a few weeks, if that. And then what are you going to do for the rest of the year? You are forced to go and buy cannabis from someone, which is illegal. And this is the point we are making. The Department of Justice, by taking the old approach, under the apartheid approach, continues to put cannabis in a criminal position. And the committee must deal with that. And if I can respond to the Honorable Masekojele, I thank her for what she's raising. And I'm glad that she's seeing how the committee and Parliament is being taken in a wrong direction by the proposals that are before you. And I'm sure if there were proper public hearings arranged in communities on this matter, it wouldn't be only Rastafari that would come there, but the large number of other people who use cannabis would come and put these points before the committee. Thank you, Chair.
Thank you very much. Mr. Ozinski, thank you for taking the time to make the presentations. Everything that you raised will be taken into consideration. One, during the process when the department makes, in fact, a response, and during our deliberations. Because I think the crux of the matter in what you are saying, even if the court said that it is the duty of Parliament to set the limits, the issue would be the test for rationality, whether 4 trees or 4 plants would be a rational decision to make. I think that is what the department also would need to convince us on. There's on top of the issues relating to constitutionality, the test for rationality, and what will be rational in these circumstances.
Thank you, Chair. I agree with you.
Thank you very much. Let's go to the next speaker. I think it's the new race consciousness.
Yes, greetings, Chair.
Greetings.
Yes, can you see me?
Yes, we can see you clearly.
Am I audible?
Yes, you are.
Okay, may I please request Mr. Ramano to share my slide? I had shared with him earlier.
Okay. Mr. Ramano?
Yes, Chair, I'm trying to locate the presentation, but yeah. I don't seem to remember getting that presentation. Did you send it via email?
Yes, via email, sir. Let me also try to.
Can you share from your side, because you've got permission to share?
Okay. It says unsupported format.
Okay, please try forwarding it to me again.
Can we take a 3 minutes comfort break and come back at 21 minutes past 10?
Okay, it's no problem.
Out this issue.
I will quickly send it to Mr. Ramano.
Thank you.
Yes. Can you please mute yourself?
All right. Thank you very much. Chair, may I proceed? Or where's the break?
No, the chair proposed that to take a 3 minutes break. So.
Oh, okay. Thank you.
Okay, we can proceed.
Okay, thank you, Chair, and thank you to the members of the Portfolio Committee. My name is Rastafari Tulompolo. I am a secretary of NRC, and I also am a PhD candidate at the University of South Africa. And I'm here to present on the hemp section in the cannabis bill. So may we please go to the first slide. Thank you. By way of background, Chair, officially, we know that in the country, hemp started to be cultivated in 1999. And the South African government established the National Hemp Foundation to conduct a research pilot on the feasibility of the hemp industry in South Africa. And through that research, because apparently research was conducted with the focus only on 3 provinces, KwaZulu-Natal, Eastern Cape, and the Western Cape. And the study's findings were that the industry is worth about 2.8 billion. That was the finding of the National Research Foundation. But obviously, the research was skewed because it was conducted only, with a few provinces, and there was focus only on a few provinces in the country. And there's still a lot of provinces that research has still not been conducted in, which may also inform a better prospects of the cannabis industry, which South African government aims to embark on. Now, the National Hemp Foundation was composed of the government officials, private sector, farming communities, and those who were designated as existing farming communities. And this excluded the Rastafari communities and incorporated other SMMEs. Now, the National Hemp Foundation was able to solicit funding for some of the SMMEs. And we know that the commercial trials were conducted under the auspices of the Agricultural Research Council, the Department of Agriculture, Forestries and Fisheries, and the Eastern Cape Department of Agriculture. And their research and those commercial trials actually proved that commercial hemp is feasible in the country, but production costs were too high, and that the fencing requirements were unaffordable for most farmers. And this is currently even cited by the current master plan, that all these requirements are limiting on the part of the farmers. Now, in 2001, the Minister of Arts and Culture and Science and Technology, Dr. Benny Ngubane, launched the Hooked on Hemp shop as a marketing strategy for the National Hemp Foundation. Now, it was reported that this Hooked on Hemp, after doing so well, and it was very successful in embarking on a human resource development program, and it was doing so well also in introducing other hemp materials. But because of the research pilot coming to a halt under the auspices of National Hemp Foundation, we found that the hooked on hemp had to shut down. So we don't understand why the black-owned company Hooked on Hemp that was doing so well had to shut down. Was it encouraged to mismanage its affairs and shut down, or what was happening? Because we still have not had the proper reporting of what happened with the Hooked on Hemp and the feasibility studies which were conducted by the National Hemp Foundation. May we go to the third slide, please? All right. Recently, Chair, His Excellency, the President Cyril Ramaphosa, in his reply to the DA Member of Parliament, Ms. Fisa, he said that to date, 83 cannabis licenses, 4 manufacturing licenses, and 3 research permits have been issued to the South African Health Products and Regulatory Authority, the SAPRA. The Department of Agriculture, Land Reform and Agricultural Development has issued 371 permits. And we can see, Chair, that already we are dealing with the bill now, but it seems as if the industry has already taken off. And the industry has already taken off at the exclusion of most of the CRL community members, especially the Rastafari community, who are also aspiring farmers, but have not even been empowered or supported to be among the statistics that the President referred to. Regrettably, this reveals that there is a systematic perpetuation of the marginalization and exclusion of the previously disadvantaged communities, including the CRL communities such as I and I, the Rastafari. And it also hints to the potential and inherent corruption, mainly due to lack of statutory bodies, which include members of the previously marginalized communities, such as the Rastafari, to monitor all the permit application and the permit issuance services and processes. Can we go to another slide, please? Now, Chair, the Department of Correctional Services, Justice and Correctional Services, has now introduced a hemp section in the bill. Now, the section 12, subsection 1 states that the minister may, by regulation, authorize prescribed activity, a hemp commercial activity. And subsection 3 states that a commercial hemp activity in subsection 1 may only be conducted in terms of a permit that authorizes the permit holder to undertake, in accordance with the terms, conditions, and requirements of a permit regulations, the activity specified in the permit, only in respect of approved cultivars specified in the permit. Now, as has already been indicated, Chair, the Rastafari community are one of the communities which are not going to be able to meet some of the requirements that the permits requires. Why is that so? Can you go to the next slide and see why is that so? The Department of Agriculture, Land and the DALRRD actually has introduced a 19-point hemp permit conditions. And condition 5 requires that there must be detailed field plans of premises, including, indicating the position of the hemp fields that must be planted and where it must be kept. And it is a known factor that no farming fields, has been distributed to any of the Rastafari national structures. Condition 6B states that good agricultural practices must be applied in accordance with the purpose. So this already indicates that there's a lot of training and empowerment in terms of knowledge around agricultural practices that also farmers need to be empowered with. And this is at exclusion of the Rastafari community, because Rastafari community currently were excluded and do not have good agricultural practices. They need to be still empowered, So this actually excludes them systematically. Now, condition 12 states that cultivation site must be fenced. It must be fenced. These are the conditions which have recently now been introduced by the Department of Agriculture. And research has already indicated that people, farmers cannot afford these requirements that the conditions have already outlined. Can you go to the next slide? Now, on the cannabis master plan, Pillar 3, research, development, and innovation is led by the Department of Science and Innovation. And we know that funding for medical cannabis studies have since been disbursed 2015 already. So cannabis research has already been conducted from 2015, and there's a 40-member indigenous knowledge-based bio program, including science councils, universities, partner government departments, traditional health practitioners, and rural and township SMMEs. There's no mention of the Rastafari there in all those 40-member indigenous bio innovation program. But funding has already been disbursed from 2015 already. So what is this? Is it a systematic exclusion of the Rastafari, a continued perpetuation of the marginalization of the community? Can you go to the next slide, please? Now, in summary, okay, thank you. In summary, the bill should facilitate the establishment of an inclusive national regulatory board, as Mr. Tapelo Khuno had earlier indicated, including even the CRL communities, such as the Rastafari, for monitoring and regulating the industry, especially the application and issuance processes. The bill should facilitate exemption of the CRL communities, including the Rastafari, from some of the pejorative provisions outlined above, arising from the permit conditions. The next slide, please. The CRL community, which also include the Rastafari students, because Rastafari also have students, as we have seen that previously, Dr. Foundation, Tandeka, and I myself am presenting now. I'm also one of the Rastafari scholars. So we are also research material. Why are we being excluded from the research activities? The Department of Justice and Correctional Services, individually and jointly with other departments, should create or use their legal instruments to incentivize previously disadvantaged communities with farmland, because already it's known we don't have farmland. So create mechanisms, legislation for us to get.
Sorry, just 1 second. Mr. Mokhotsi, please mute yourself. Sorry for that. You can proceed.
Yes, Chair. We are saying that the South African government has the capacity through its legislative processes to use those instruments to incentivize the people that they know, the Rastafari community and other communities which have been disadvantaged, which have vested interest in the plant, to meet the permit requirements. Otherwise, we are just being entrapped that the industry should take off at our exclusion, and this would be deliberate because we know what we can do to empower. Thank you, Chair.
Thank you very much. New race consciousness. Are there any questions? Mr. Makulubete, followed by Honorable Masako Chele.
Thank you very much, Chair. I just have one question to the presenter. And I must confess, Chair and honorable members, that as from yesterday, I've been getting mixed signals as to the different understanding of cannabis and hemp. And from the slide that was presented now, slide 3, there is seemingly a distinction between the two. Other presenters were of the view, or they have submitted, that there is no difference between hemp and the cannabis. And now, on slide 3 of the presentation, it is stated that 83 cannabis licenses were issued. And also, second, that was a bullet number 1. And bullet number 2 says 371 hemp permits have been issued, basically in terms of a background to that presentation. Now, I would like to find out from the presenter, and maybe other presenters may give input on this question as well, just for clarity, because now I'm getting confused bit by bit as to, is there a difference between cannabis and hemp? And if that is the case, what are those differences? And the differences, if there are, can they be determined in terms of the THC content, or the height or the width of the plant itself, or even the flowering or the tops of the plant itself? Because now I'm getting mixed signals on this aspect, Chair. Thank you very much.
Thank you, sir, for the question. Chair, may I answer?
No, sorry, you will answer first, get all the questions. There's another question from Honorable Maseko Chele.
Thank you, Chair. No, one is noting the presentation by Mr. Tulo. Is it Tulo? And Chair, I think, no, I won't have a question, but I would want to know from Mr. Tulo, because he keeps on saying he has been marginalized, he's excluded. I would want to know exactly who is excluding Mr. Tulo and the team, and also how would he be? Would he like to be included in this? Because these things, Chair, like for example, today we have presenters and the information was out there, and those who wanted to come, they came, and there can be allegation of some people who did not come, who just did not come, and then later they have these allegations that they are excluded. Because that matter of exclusion, it has to be addressed. If we leave it like that, it is like there is an intention to exclude Mr. Tulo or Mr. Mpulo on these things. These things are outside there, their website and all those things. Now, if we would have this emphasis on excluding people coming to the committee, we would now have to divert, from the real issue that we are about here, Chair. I would want to hear from him exactly where is this exclusion coming from. Thank you, Chair.
Thank you. Over to you, new race consciousness.
Okay, thank you, Chair. Chair, with regard to the first question about the hemp and cannabis, Chair, we also don't see a significant difference other than one is the female plant and the other is a female, one is a male species and the other is a female species, and the one has higher THC content, the other has a lesser THC content. But in our submission as New Race Consciousness, we did make mention that we just about make use of hemp and cannabis in the same way, which is why even our elder Dr. Foundation, chairperson of the Rastafari National Council, made mention that there should be we should be allowed to regulate on our own as Rastafari community the cannabis and hemp, because we've got our own conceptualization and our own understanding of the plant and how to regulate it, different from how the South African government want to separate the plant, And then in terms of who is excluding us, well, I know that the master plan has outlined the stakeholders. So the master plan is actually spearheaded by the Department of Trade and Industry. The Department of Trade and Industry, together with the Department of Agriculture, are excluding the Rastafari aspirant farmers and Rastafari communities, basically to empower them with farmers, because we don't have farms, and yet we have vested interest in the cannabis industry. And the president himself, when he made mention of the KwaZulu-Natal, he made mention of Eastern Cape, and he made mention of Western Cape, but he left out many provinces. We feel excluded because I am from the Free State Province, and I know the Free State Province, augurs very well for industrial cannabis. So we also feel that the president was limited in his information because he got obsolete research. Research should be updated, and research should be conducted, including other provinces, Free State as well, and including even now the Rastafari. Rastafari people must also be included in all the research because research primarily informs what will happen next. It informs the new product uses. It informs everything else about the industry. So if we're excluded at the research level, majority of us at the research level, then we're doomed.
Thank you very much. New Race Consciousness, thank you for taking time to contribute to the making of this bill. Thank you very much. Can we now move to Ms. Moleboheng Simela? Ms. Moleboheng Simela.
Thank you, Chair, and thank you very much, and greetings everybody for the opportunity. Chair, at court now, and my colleague Ras Mandla is going to be presenting on my behalf. If I can just ask the Chair and the committee just to call me after the presenter that you can call now, so that I can sensitize him that he can be in. Thank you, Chair.
Can we move to fields of green for all? Can we move to fields of green for all? Committee Secretary, do we have them on the platform?
Yes, Chairperson, she is on the platform, but I don't understand why she's not responding. Maybe we should move to Afghanistan.
Okay, I can go through, Chair, under the mercy of the network. I'll be brief as I can. Thank you again for the opportunity. Mine is going to be very short, Chairperson.
Sorry, Ms. Moleboheng, you are really confusing our program.
Okay, I'm sorry.
Because once you ask to be skipped, most probably everybody else is waiting for his or her time, and it takes time now for people to readjust. That is why. So if you can proceed, it will be fine.
Thank you very much, Chair. Thank you. Under the mercy of the network here. Thank you again for the opportunity. My name is Moleboheng Simela. One of the hemp manufacturer. I'm doing cosmetics. Regarding the Department of Agriculture requirements when coming to permits, I submit that they should give us allowance of planting hemp as much as the sunflower crop has been planted, as much as the maize and any other crops. They must not limit us to the 50 hectares because the permit is saying we should plant on 50 hectares. 50 hectares, in most cases, won't even talk to the volume of us producing what we want to produce. If I need to extract oil, I need a volume of hemp to do the CBD or the fiber for that matter. So that matter of 50, it's very, very little. They can say minimum of 2,000 hectares because it must be as vast as possible. Second one is that we need the exemption also as Rastafari community based on the past atrocities that our elders, even ourselves, like I'm in court even today because of the same thing. I must be a witness because someone was arrested for something that I didn't know if it's cannabis or hemp. So we need the exemption because of the reparation and the compensation that we demand. The third one, my chair, it is the CBD level and the THC level that we get from the hemp. Like the question from another panelist is asking the difference between the two. It's one plant, but male and female. The male part don't have volumes of THC. Like now, the volume of the CBD that they want, like I'm in the incubation program currently with the CSIR, whereby the plant, the material that I submitted, most CSIR, they are telling me that the volume of THC is high. But I know for a fact that I can't even puff that for recreational purposes, because for recreational, we puff something with a high volume. So now what I'm saying is that they should also visit that act or whatever the law that they're trying to put to say that certain amount of THC must be on hemp. It must be at least 3%, because our sun, it is strong, our heat is stronger more than the one of Western, like the way the adoption of the Western cultures and the policies that they are not incorporating in South Africa. They must visit that, because really and truly, the University of Free State has the data that our plants are good the way they are. We just need to develop better policies that talks to our environment, our climate, so that we don't get arrested unnecessarily, or we get our permits withdrawn or scratched or cancelled because of the THC level, while we know exactly it's hemp. So hemp have THC, and they must recognize that and acknowledge that. So that is why we're saying at least 3% of the THC on hemp. Again, the other one is on the research. They like to promote research more than commercialization. We are ready to do business. Like, we just need to be taxed for the end product when we are selling whatever the product that you are doing with hemp. Unlike they want to regulate the plant itself, and then that does not talk to us. It still put us under pressure. So the laws are still the apartheid laws. We need the laws that talk to us. We need more intense engagement, whereby we can even teach the government about the plant as indigenous people, because we've been doing it so long. So I'm also a researcher for the University of Free State. As I'm saying, as a company, my state is there. Professor Matabisa can attest that South Africa don't need the seeds that are coming from overseas, and we don't need Chinese seeds. We have our own seeds. Have time and mercy and apology to say this, my chair. The issue of commercialization, it is not even relevant to the Department of Justice and Correctional Services. This we should be discussing with the Department of Trade, Industry and Competition. We should be discussing with the Agriculture Department and also Department of Health. With those few words, I will say I thank you for the opportunity, for the time and space, and I hope that our contributions can be recognized and be added in these policies that you are trying to develop. I thank you, Chair.
Thank you very much. Thank you let me check your name again. Thank you very much, Ms. Simela. Thank you for your contribution. Any questions or comments? Honorable Maseko Jele.
Thank you, Chair, and thank you very much for Ms. Simela. But Chair, only one question that I would want to hear from Ms. Simela is that where are they really missing each other with this department? Because it seems as if there is no correlation with the information that they have, especially with universities and the information that is coming from universities, as she is indicating that she's a researcher, with the department. Exactly where is the missing link? Where are they not? Why are they not finding each other, if I may ask? Thank you, Chair.
Thank you very much. Any other question or comment? I think that is the only.
Come on.
I think that is the only question. Ms. Simela.
Okay, thank you for the question, Mayor. I will assume, because I'm not government, you know, me, I'm a consultant, I'm an agent, I'm a private company that is claiming a space in the cannabis industry. And we see this gap because from the previous DG of Health, Mematsoso, every time there was interdepartmental meeting whereby the stakeholders like ourselves were invited. After that, she changed from being the Director General of the Department of Health. Things have changed and we don't get consultations whereby we can engage in them. Like now I can respond to say, where is the loophole? But there's a bridge between all these because at the end of the day, they don't get it right because they don't also invite us anymore to sit down and assist with the experience and the data that you are having. Like I am saying, University of Free State, I've been supplying the cannabis material for the past 3 years or so. The data is there, that can be given anytime. But if the DTIC is there and they're doing their own things, I'm not government, I can't even say why, but what I can say, they failed to engage us and invite us in other issues related to the legislation or whatever policies besides this committee. And I still give thanks for this committee for being consistent in inviting us. Otherwise, the Department of Correctional Service and the Department of Trade and Industry and Health and Agriculture, I don't know how far they and what they are doing. Only maybe the president knows. That is why the Rastafari National Council is even demanding to meet the president so that we can get a sense of why the delay tactics. Why do we still feel like we're in the apartheid? Well, it's not apartheid. Why we are not free to exercise the value chain of hemp and cannabis? I thank you for that question. May I hope that the council also or the department can follow up with these other sisters departments.
Chair.
Honorable Taylor.
Yes, it's only, I missed the question. She was indicating that they need how many hectares? Because here we are talking about 50 hectares. She said something like I don't know, it's 200 or it's 2,000 or
2,000.
Okay, 2,000. Thank you, Chair.
Thank you very much. Mr. Makulubete.
Thank you very much, Chair. It will be a follow-up to the response that she has given in relation to the differences between hemp and cannabis. Now, the response or the sense that I'm getting from her seems to be that there is one plant and it can have THC concentration, and in the same plant we can have a CBD content. That is the content that is not psychoactive. Now, I will want to find out if that my understanding is correct on that, and I will request that a clarification be made further on that, because in the past we have been hearing, and even from the news articles, that the spraying of the fields were because the plantation was of a certain height, and if that is that the height that has been seen is of a certain level, then it means that is cannabis. That is the cannabis with a high THC content. But if the plant is at a certain lower level, it means that is CBD, that is hemp itself, the plant that does not have a THC content itself. So now, both plants, if they are two different plants, both plants will have the tops, the ones that are folded a chair and then smoked. If that is THC, then one will get high. But if it's CBD or a lesser THC content plant, one cannot be high. So now, the sense that I want to get is, these are two different plants, one without THC and then one with THC, but of a higher level of concentration. Or there's one plant with different parts of the plant consisting of THC concentration and the other with a CBD concentration. I'll request clarity on that. Thank you, Chair.
So where did you read that? Mr. Makulubete?
Chair, it will be, it's quite a long time when we are doing research in relation to the first draft of the bill, checking the various newspaper articles and other research articles. But so, that was my understanding of, I cannot give a specific reference and at this stage, and I do apologize for that.
No problem. But what I wanted to understand, of which I think you have answered, was it a research article or just a newspaper article?
It will be a combination in other research articles or the newspaper articles, where especially in the newspaper articles, it will be in relation to the spraying of the fields, the hemp or cannabis fields. Those will come from the newspaper articles, because that's where we get the responses from the police as to the spraying and the reason for that, because the my understanding was that the height of the sprayed fields were essentially the cannabis, the one that has got THC concentration, which at that time was still illegal before the Constitutional Court judgment. Thank you, Chair.
Thank you very much. Ms. Simela?
Yes, Chair. Just to be brief, answering that it is not a matter of the height for one to say it's hemp or cannabis, you know, because you can have a female that is looking like a peach tree, big enough like that. So it's a matter of the volume of the THC, like you are saying. You are right to say that if the volume of THC is higher, that means it's a female plant. But then if it does not have the volume of when you puff or when you smoke for recreational purposes, you don't feel relaxed, or you still feel your pain, you want to numb the pain or something like that, that means it's hemp. You know, it is not a matter of the length. The length got nothing to do with the determination of the THC content or the CBD content in it. It is true. It is one plant. On that same plant, you get the THC, you get the CBD, you get CBG, you get Delta 9. There's a lot of potencies and like different benefits you get from this one plant. But the one with the low THC is defined as hemp. That is what we are saying. They should consider, because you can find that it is 0.2 THC, but you still don't feel like you are smoking the cannabis that you're expecting of, which is the medical cannabis. But they are saying it's cannabis, you know? They say it's hemp, I mean. That is why we are saying the agriculture must really visit their regulation on these things that permit, because we're going to be finding ourselves planting hemp, but scientifically where they're going to research or test it, it can give volume that they say we must not have, while it does not give you a psycho-effective, if the house understand my point. So that is how it is. It's very, very funny that when the likes of that just spoke now, when they want to conduct a research, they'll go to papers and articles that they cannot find now. While we are here as warm bodies and as organizations, and we've been making noise to say that we are here, include us when you're doing these policies and regulations, because at the end of the day, nothing for us without us. You're gonna get it wrong, you're gonna be wasting time, people wanna be facing arrest that are necessary, and defamation of characters and the criminal records that are necessary. Please be the government for the people, by the people, for the interest of the people, not for the interest of other people that we don't know, because all these regulations does not talk to us, because it is just researches on papers, on Google, but the engagement does not come to us. And we are still waiting for the National Council of Provinces to come so that we can really engage also face to face, so that we can feel the pressure that you are having on the ground. Thank you, Chair.
Thank you very much. Honorable Jelle, is that a new hand or an old hand?
It's a new hand, Chair. No, it's just one request, Chair. I think, Chair, because here we need to close this matter very soon, as we were talking about it earlier, that we are at the final stage. But whilst we are working, Chair, can the department finish us with this research? And also, even Mr. Simela, if he has those documents, he can give it to them so that we can assist to make this thing to be, in fact, we meet each other close with the bill that we are doing. So if we don't have such information, Chair, we will definitely not be able to respond to what has been raised properly. I think in tweaking the bill that we are having, if we are going to go that route, because we are about to finish. So the best thing, can we receive those researches? The department must also assist us. They can't be the only ones who have that information when we are the ones who are supposed to make decisions on this. So can we be finished with those research documents summarized for us, so that we can be able to have an informed decision on this matter without delaying this bill, Chair, because we have to conclude on this bill. It's one of our bills that we have to finish before we go to the next we leave Parliament of the 6th Parliament. Thank you, Chair.
Thank you very much. But also, to be fair to them, there is also a lot of information. I remember it was Sarah that we were given on this issue of THC. They can give us the specific one, but there is, if we go back to our packages, we will find that there is information that we were given from which the department based their decisions, but they can just, in case members do not have that information, they can just update us. Can we move to the next presenter? Thank you very much, Ms. Simela, for the presentation and for taking time out of your schedule to do the research and to make the presentation.
Thank you, Chair. Thank you very much.
Thank you very much. And we go to Fields of Green for All.
Hello, Chair. Hello, everybody attending.
Yes,
my name is Motel Clarke for Fields of Green for All. Can I proceed?
Yes, please proceed.
Honourable members of the committee, we have previously submitted comments and given oral representations on 2 occasions. We refer to questions asked previously which remain unanswered. Where's the credible scientific and academic evidence upon which this bill is based? And why are there questions right now that are very, very basic questions when it comes to the THC contents and the nature of the cannabis plants at this late stage in the drafting of this bill? Are we to expect the passing of this bill through Parliament to proceed without such evidence? My second question that remains unanswered from the last session is, who is going to come and count my dacha plants? Will the South African Police Service be charged with counting, measuring the plants, measuring the THC levels of an estimated 20 million South African cannabis users, cultivators, and traders in order that they can enact the irrational and unconstitutional criminal penalties suggested in this bill? The word decriminalized is often used to describe cannabis in South Africa post the 2018 Constitutional Court judgment. This is highly inaccurate, and this bill shows no signs of decriminalization. For cannabis users, cultivators, or traders in South Africa. Criminals are people who harm other people. It is 1,056 days since my partner Julian was shot dead at 2 a.m. in our bed. The person who shot him is a criminal, not me and my dacha plants. It is also criminal that the South African Police Service has never investigated his murder. There is nothing I can do about that. But there is something I can do about the threat of criminalization hanging over the heads of our South African cannabis community, and I will never give up fighting for our rights to evidence-based laws and regulations. We would like to bring to the committee's attention an email sent yesterday by the head of our legal team, Paul Michael Kachel of Cullinan and Associates, explaining the exact legal parameters of plant counting and the law. I trust that the committee and the numerous legal minds before us today take note of the facts contained therein. If these legal facts are not taken into account, civil society will be forced to present these facts in court. This will be at our personal expense, but the government can rest easy that all expenses related to another court challenge will also be borne by civil society, by us, the taxpayers. That is ironic and a travesty of justice as we all gather here and say the same thing over and over again. Fields of Green for All would like the committee to note that of the 19 submissions presented over these 2 days, excluding us, 16 organizations, companies, and individuals are directly aligned with Fields of Green for All. Our aims, objectives, and values are the same, and we all support each other. Our objections to this bill should be seen as one voice, and we are all in a clear majority in this room. We would also like the committee to note the presence of Doctors for Life, the only prohibitionist group represented here. In 2017, Doctors for Life and the state were the reason that our case was rendered part heard in the Pretoria High Court. Our opposition spent 3 full days arguing against the live stream of the trial. We won that live streaming case in the Supreme Court of Appeal with a costs order. To date, neither our attorneys or the sheriff of the court has been able to locate Doctors for Life in order to effect that costs order and reclaim our expenses. The state has also not paid that costs order. It was with great surprise that we noted the presence for Doctors for Life here, as they remain in contempt of court in this matter, as do the state. Fields of Green for All spent 6 years researching, compiling, and publishing our manifesto. This guiding document was introduced to this committee during our very first presentation here. Yesterday, the question was asked, well, what are your solutions? Here are the solutions. This committee has had 5 years to come up with credible, evidence-based solutions, but has ignored our hard work as civil society. All 15 entities mentioned above, plus many more organizations, companies, and individuals, both here in South Africa and around the world, support this document. We would suggest that the honorable member who asked the last question reads Cannabis in South Africa, the People's Plant, a full spectrum manifesto for policy reform. All of your questions over the last 2 days are answered in a clear, summarized, easy to read version in our document. We also have over 2,000 academic references that are footnotes in this document, and they will answer all of your questions. If you don't believe what we say, then go to the academic papers that we used to base our work on and go and look for those references. We have done the work for you, ladies and gentlemen. Now, please just accept that we have done this work and go and read our document. Fields of Green for All has special consultative status with the United Nations Economic and Social Council. We are considered leaders in our field and have presented our position to communities in every corner of our country and further afield, from Nigeria to Montreal, from New York to Vienna. Next week, I will be speaking at the African Futures Conference in Cologne, Germany. On the invitation of the university there and the universities of Bristol and Cape Town. Internationally, our voice is heard, but our own government ignores the content of our submissions and the submissions of our colleagues over the last 2 rounds of these hearings. Fields of Green for All notes that comments are only invited for sections on the draft bill pertaining to industrial cannabis. Why is the subject of the use, cultivation, and trade in industrial cannabis included in a cannabis for private purposes bill, but there's no regard given to the personal and private use of industrial cannabis? Where are the protections for uses for our unique, diverse, and climatically appropriate land-race cannabis cultivars that have been the cornerstone of rural cannabis cultivation in South Africa for centuries? This is given the threat of important hemp varieties, pollen drift, and unscientific THC thresholds. This plant should be regulated according to the end use and not according to the cultivation. These debates backwards and forwards about THC levels and heights of plants and CBD and this and that and the other are irrelevant. This should not be regulated according to cultivation. It should be regulated according to end use. Forget about the THC and your moral judgments against me getting high. I am not going to repeat all the salient scientific facts about industrial cannabis that have already been addressed by colleagues, most significant by Ignite and Cure Laboratories yesterday. Safe to repeat that experience the world over has shown that industrial cannabis laws and policies that look more like drug then agricultural laws and policies fail in all aspects. Fields of Greens for All's position on the Cannabis for Private Purpose Bill remains unchanged. Within our far-reaching constituency and including our fellow civil society organizations engaged in intensive work around the re-legalization of cannabis in South Africa, we have not come across one credible individual, organization, academic institution, or expert who is of the opinion that this bill will pass constitutional muster. Criminal offences continue to make up a large part of the draft bill. Scientific evidence of harm that would justify such harsh penalties is just not there. The continued laborious breaking up of the definitions of cannabis, quantities of cannabis, cannabis and privacy, cannabis for communal, traditional, religious use and cultivation is a symptom of the lack of awareness on the part of the legislatures of the dire need to reform the relationship between cannabis and law enforcement. That is, arrests, incarceration, labor issues, and family law matters. We know, and this was mentioned by our attorney and representative of the Umzimbubu Farmers Support Network, Ricky Stone, yesterday, that there is work being done on all purposes cannabis in line with the promises made by our president in numerous State of the Nation addresses. This committee has only itself to blame for wasting 5 years on an unconstitutional bill. The upcoming elections cannot be used for pushing this bill through and forcing us back to court. Further to comments from yesterday around cannabis in the workplace and cannabis and driving, we would like the committee to note very precisely that cannabis is stored in the fat cells of the body for approximately 30 days. Presence of cannabis detected in a urine test or a blood test does not indicate impairment. In other words, does not indicate that I am high when I'm at work or I'm high while I am driving.
Thank you very
Saliva
much.
tests that indicate impairment,
Thank
either
you.
at work or at the roadside, are only the accurate way. These saliva tests are very new and have
Ms.
only
Clarke?
arrived in South
Ms.
Africa.
Clarke?
Will you please just allow me to finish? This is
Ms.
very,
Clarke?
very important.
No, Ms.
Yes,
Clarke, please.
I will finish
Everybody-
now. I will finish now.
Everybody has the
Please
same
allow-
time, please.
I
No,
understand.
no,
I understand.
no,
I'm just
no,
explaining that
no,
that saliva tests.
no,
I will finish.
no,
Okay, let me
no,
conclude.
no,
Please, can I just conclude?
no. I've given you an extra minute, still you did not conclude. No. No. Can we move to questions? Any questions, members?
Where's the thing? Where's the hand?
Can you mute? Any questions? Thank you very much. Can we move to the next presenter? Thank you very much, Ms. Clarke, for the presentation and for taking time.
I'm very upset that I haven't been allowed to conclude. I had 2 more sentences to say.
Everybody has the same time. Thank you very much. Who is the next presenter? Can you assist, Committee Secretary?
The next one is Afrista, Chairperson.
Thank you.
Good afternoon, good morning, Chair, and good morning to the committee and to civil society. Please, can you share the screen so I can show my presentation?
Yes, please go ahead.
Is it set up for me to share? Oh, there it is. Thank you.
Your time starts now.
Right, thank you very much. My name is Nicholas Heineman. I'm a director of AfriStar. We are a cannabis, we're partly a cannabis lobby group. We're also a Section 21 company focused on rural development. We work with a lot of people that have presented in this room over the past 2 days. and we've also worked with different aspects of provincial governments in the country and assisting DTI with country competitive strategy around cannabis. Not going to go into that. I think there's been a lot of discussion today around these THC levels in the plant and regulating hemp around THC. So I wanted to go back to the beginning of this. And the beginning of regulating cannabis started with the government on an international level, started with Jan Christian Smuts in 1925, where they wrote to the then League of Nations and asked for cannabis to be included so they could regulate it. So our colonial government asked for cannabis internationally to be regulated as a way of subjugating the African people of South Africa. I think it's really clear. And then since then, there has been a whole series of international laws that were drafted around that first application that we saw brought in the League of Nations, and then landed up with what we have today, which is 3 conventions, international conventions that guide the use of cannabis around the world. And those are the Single Convention of 1961, the Psychotropic Substances of 1971, and the Convention Against Illicit Traffic in Narcotic Drugs of 1988. And then this is policed by the United Nations Office of Drugs and Crime. Okay, none of these conventions, sorry, I've got to go back. None of the United Nations conventions define industrial cannabis or hemp, and I'm calling it industrial cannabis because I'm wanting to open the door to use what we've got in South Africa, our land-raised cannabis. And if we keep talking about hemp, then hemp is traditionally looked at differently. So I'm talking about industrial cannabis, cannabis that we use for industrial purposes. Okay, and none of the United Nations conventions define industrial cannabis by THC levels. So that means there is no consensual taxonomic or phylogenetic classification for industrial cannabis or hemp. Okay, Article 1 of C61, which is the first convention, the definition of the cannabis plant refers only to cannabis plants used for the production and manufacture of drugs. And then it further qualifies it between drug and non-drug products. So and then it goes on to elaborate that the convention shall not apply to the cultivation of the cannabis plant exclusively for industrial purposes, that is fiber and seed or horticultural purposes. So this raises the question, does industrial cannabis or hemp have to be regulated? We've seen in the conventions that it said if it's used as a recreational drug or as a medical drug, then we are bound as a country to regulate it, and we have to report to the United Nations. The categorization of cannabis sativa L as industrial hemp and the establishment of legal definitions for industrial hemp based on its THC content that the member from the Justice Committee has been asking about today, the content has been regulating by THC content is a recent development that came from prohibition. Before that, in the 1800s, when hemp was used broadly as the cornerstone of the Industrial Revolution to make canvas and oils for the machines and shoes and uniforms and sails and ropes, that was just land-raised cannabis. And we see that India, Nepal, and Chile and China use traditional land-raised varieties of cannabis sativa for industrial purposes, even today. And this is further highlighted by the official commentary published by the United Nations Secretary General's Office that says that the control regime applies only to the cultivation of the cannabis sativa plant for the production of cannabis and cannabis resin, i.e. drugs, and hence the cultivation for any other purpose and not only for the purpose mentioned in paragraph 2, industrial purposes, fiber and seed, is consequently exempted from the control regime provided for in Article 23. So what does this mean? It means that South Africa as a country only has to report on illegal cannabis cultivation and seizures and legal medical cannabis cultivated under the controlled license conditions. There are no arbitrary THC levels in the plant stipulated. the United Nations and the conventions do not say that we have to have 0.2% or 1% for the plant to be considered hemp. It says very clearly the plant is industrial if we say it's for industrial purposes. So what the previous speakers have been saying, we regulate for the end purpose. If it's going to be used for industrial purposes, you do not regulate the plant in the ground. If we choose to use the term industrial cannabis, South Africa then create our own regulations for industrial cannabis, which is what we're trying to do here. And we should do that based on what we have. And then we position the country to unlock the potential competitive and comparative advantage that we have. We have more cannabis production going on in South Africa than they have in the whole of Europe growing legal hemp at this stage. So our competitive advantage is scale of production, drought-tolerant species, experienced small-scale farmers, naturalized genetics. And it's essential to make provision for our indigenous landrace cannabis to be cultivated for industrial purposes. I'm going to go into this. This is super important for us in South Africa to describe, to understand what is our landrace production. The picture on the right is the upper Umzimvubu catchment, which is a small part of the eastern Cape near Lusikisiki, where research that we helped sponsor was done in the last 18 months. I'm going to try and quantify how much cannabis is produced in South Africa so that the committee can understand what we've got and the importance of trying to unlock what we have, because we can't do that by imposing Western limits on what we have. It's just never going to work, and we're going to always exclude our traditional farmers. It's very difficult to quantify because it's been illegal. We are required by the United Nations Convention to submit something called an ARQ, which is the annual reporting questionnaire to the United Nations Office on Drugs and Crime, who published the data in a report. The highest figure ever reported was between 82,000 and 83,000 hectares of cultivation in 1994 and 1995. This was supported by...
You are left with 2 minutes.
We were supported by the US Drug Enforcement Administration, who estimated 20 to 30,000 hectares. Okay, and SAPS reports 22 to 7,000. So the research that Timon Goerten, who was doing an MSc from Wageningen University in the Netherlands, he reckoned that we have about 40,000 hectares of cultivation in this little part of the Eastern Cape. And that means there's 40,000 farmers in that part of the Eastern Cape. And that the industrial value of that crop in the ground, as it stands today, that has no market, is 451 million for 40,000 people. That's without looking at the medical or the recreational. If you could include the medical or the recreational, then it goes up to 5.9 billion. This is what we need to unlock for South Africans to participate. So to summarize, this bill as it currently stands is overly restrictive, counter-revolutionary, anti-development, anti-Black, and not pro-poor, and it has no sound reasoning for following this approach. The United Nations does not say that we have to control cannabis used for industrial purposes. We can create our own regulations, and we are effectively saying that there should be no limit on THC quantities in industrial cannabis, and that cannabis used for industrial purposes should be regulated at the point of process and not in the field. It means the processing plant can get a license and they can be responsible for reporting to whoever it is they need to report to, but the farmer should not be responsible for that. And this would make provision for our indigenous landrace to be cultivated for industrial purposes, irrespective of THC levels and defined by the end use. And this would include the tens of thousands of hectares and farmers of existing cannabis production. Thank you very much.
Thank you very much, Mr. Heineman. Are there any questions? Honorable Maseko Jele, followed by Mr. Makulubeta.
Thank you, Chair. I just want to find out from the Mr. Nicholas, in the manner that the bill is right now, currently, You have indicated so many things that you would like the issue of the limits we are limiting ourselves in terms of what is happening in Europe. So if you can give me from the bill as it is currently, what is it that you see, maybe one or two that you have not mentioned, that you think that it can be improved or changed, because the bill is not from other presenters. They feel that it is okay to have a bill, but we need to twinkle one or two things. One or two things. Thank you, Chair.
Thank you. Mr. Makulubete.
Thank you very much, Chair. Just one short question for Mr. Heineman. I'm thankful to him for the presentation. Mr. Heineman, your presentation seems to use the term industrial cannabis and hemp interchangeably. I would like to find out, is this how it should be? Or is there a difference between industrial cannabis and hemp? Because the new clause relating to hemp commercialization makes reference to hemp and not industrial cannabis. Will there be maybe then a risk of creating a confusion by referring to hemp instead of industrial cannabis? Or is it okay if we refer to hemp as it is, in your view? Thank you.
Thank you. Can I proceed, Chair?
Yes, we can.
I think to respond to the first question, what can we change or be improved? I think we keep trying to regulate cannabis by a THC levels for industrial purposes, what we call hemp. Maybe I'm going to answer that last question first, because then I can answer the first question. As I tried to explain in that presentation, there is no real international accepted definition for what we call hemp. It came about as a result of prohibition so that we could still use cannabis for industrial purposes, but we would only use lower THC versions. So some of the regulations that the more modern ones we see in the European Union and the United States Farm Bill, they actually define hemp by THC levels. What I was trying to say though, is traditionally, we haven't defined hemp by a THC level. We have defined it by how you use it. So if we're wanting to use what we've got, which is tens of thousands of hectares of traditional farmers growing landrace cannabis for industrial purposes, it's not essentially hemp, it's industrial cannabis. And if we keep saying we're going to use hemp and we're going to define it by THC, it is automatically excluding that plant, that genetic, and those farmers from the industrial value chain. And I think that's what we're trying to avoid. So if we had to improve the bill as it currently stands, we must understand that we are making a choice as a country to define things in terms of THC levels. We are not bound to do that by any United Nations convention or treaty that we've signed. So if we are putting in the definition that defines it at a certain level of THC, we must be able to reasonably explain why we have chosen to do that. And we should understand that it excludes the volume of cannabis currently being produced in the country. If we can utilize the cannabis that we are currently growing by those traditional farmers, tens of thousands of them, we don't have to go and reinvent genetics, and we don't have to teach people to produce. They're already producing. All we have to do is facilitate the processing of that into value-added commodities, hemp, fiber, paper, all sorts of things. I've tried to explain it as short as possible. Happy to answer more questions. Thank you.
Thank you very much, Mr. Heineman. Are there any further questions? None. Thank you very much, Mr. Heineman, for taking the time to make your presentation and to try and enrich this particular process. It's not an easy process, but I think the contributions that each and every one of you is making makes it a little bit easier for us to grapple with these difficult concepts that are here. Thank you very much.
Thank you very much.
Thank you very much. Let's move to the next group, which is Cannabis Action Group. Cannabis Action Group. Committee Secretary, do you have them on the platform?
Yes, Chairperson, Mr. Andre.
Sorry, Chair, I was outside. I was expecting only to speak at 12:20, so this is, you can just give me a second.
Can we start at 11:32?
Okay.
I hope you are ready now.
Yes, I'm ready, Chair. I don't know if I can be seen or if my presentation is available to be shared by the Secretary.
Can you share the presentation?
Okay. Okay. Morning, Chair. Morning, everybody.
Yes, but we don't see the presentation.
It should be coming up.
The presentation is there, Chair.
Okay. You can proceed.
My name is Andre Duplessis from the Cannabis Action Group. I started the Global Cannabis March section here in South Africa 23 years ago, and we've been peacefully demonstrating to the steps of Parliament for the past 23 years. So excuse me if I'm not as polite as some of the previous people, but it's been a long time for me, more than 5 administrations. I, like others that have presented before this round, will make sure that I only focus on the hemp tax-on that the uninformed members of this committee have presented so proudly as their homework. But before I continue, I need to point out that if the committee members had in fact done their homework, I would not have to speak here today. In my previous presentation, both written and oral, I gave indisputed evidence of the hemp research that the government has performed over the past 2 decades to the cost of more than 1 billion rand. And yet, here we are. No scientific evidence for 1 billion rand, not a jot, to justify what you call hard work. If you had listened to just me or read just my presentation, this would have been apparent. But not only have I been ignored in the saliva on the paper public participation process, but so have all the other presenters who have raised the exact same topics. And the thousands of marchers that have marched to the steps of the parliament over the past 23 years for the liberation of cannabis. Instead, what do we have? Further definition insanity. More bad definitions that will be a gaping corruption hole and the criminalization of citizens. I have not seen this government make any representations to the International Code of Area Nomenclature Board to change the phytosociology or well-defined words to match the cockamamie definition in this bill. I say no for these reasons. The harm, THC, that these legislators want to lock me up and others for, like I presented last time, slip and slide up and down the harm scheduling at the threat of legal action. And I, like others, and like I presented last time, are exactly like the vaccines that we authorized for use, which were not regulated by molecule, like cannabis is here, which means the billion-rand scientific yardstick is broken. Because it's becoming abundantly clear that the molecules in the vaccines appear to be much, much more harmful than cannabis over just the past 3 years, and even since my last presentation. Yet, depending on your chosen deity, the slip-slidey harms of a molecule vary. The slip-slidey harms of the molecule also vary between private and not private. And I just like to question the science that informed this committee, because what has been printed in this bill shows that THC, the harmful molecule, can exist in 3 different states at exactly the same time. Now, to me, the only thing that can explain this is quantum science. And I hope in the questions and answers, we can figure out a little bit more about this quantum science. Were the molecules in the vaccine scheduled by harm, religion, private or not in private? So before you judge me with your limited understanding as a criminal, let me school you. On the screen, you are seeing the average UVA and UVB that reaches the planet's surface in a year. Red is lots of UVA and B, and blue is very little. Please focus on the 40-degree latitude that runs between Canada and America, through France and Spain, and through Athens, Greece, and in the south through Chile and New Zealand. The blue zone does not get much UVA and B because of the general water vapor in the atmosphere. To put it simply, it's a UV thing. THC is created through a bioenzymatic process created by the cannabis genus when exposed to UVA and UVB. These are well understood and standard nomenclature terms. In other words, scientific terms that are obviously too complicated for this class and time. So back to the colorful picture. To simplify, here above the line where the white people live, hemp, because it doesn't produce THC. Between the 2 lines where there's lots of red, and there's lots of sunshine, lots of UVA and UVB, cannabis, brown people live there. Anyway, these hemp inclusions and new definitions and the previous ones that I raised before will ensure through the lack of understanding of this picture and where hemp grows and where hemp doesn't grow will fail by what is already included in black and white in the hemp edition through its definitions and its THC percentage. I said before, terrible definitions. And here we are 2 for 2. That's exactly something that's actually worse than the previous bill. And right there's an example of how a bad bill introducing bad law can be removed from the table. The legal advisors of this committee actually retorted to our previous presentations that Parliament does not have to engage in public participation every time it changes the law. In the case when definitions are changed to a language that seeks to criminalize citizens outside of internationally understood nomenclature, that is exactly why and when Section 195 public participation is required. Members of this committee, their legal and health regulatory advisors, have often cited the single convention treaty as the overarching guidelines. But here's the thing. I'm not presenting to the World Health Organization or the United Nations. I'm presenting to the South African Parliament. And on top of that, last time I presented the existing levels of latitude allowed in the existing treaties of member states not to criminalize their citizens. And as an example, there's the whole of America, a signatory example, yet here we are. Further to that, and in closing, as if the definitions used in the bill aren't bad enough and Eurocentric, from above the blue zone, hemp definitions are being applied here in Africa, and these sitting legislators are choosing to criminalize citizens based on no science whatsoever. As for the term approved cultivars, we've just recently had an experience of approved vaccines. Do you think I'm going to trust the government when it comes to approved cultivars? Anyway, I have a serious question I hope to get in the questions and answers, because to me, this smells like regulatory capture. What's on the screen? I'm just going to leave up to the legislators.
You have 2 minutes left.
Obviously, you haven't seen it, or again, this bill would not look like this. What you have is the new World Health Organization principles that encourage not criminalizing member state citizens for all drugs, not just cannabis, but all drugs. Now, if the legislators had seen this, this bill wouldn't look like this. If the legislators are choosing to do what they are choosing, despite not having the science to back it up, I make a few predictions, one promise. Every African who invests in hemp as defined in this bill will lose everything in style. The bill is nonsense, complicated, and corruption will be resolved. This bill will face opposition in court if this committee continues. My promise is I will hold every legislator accountable for choosing to make us criminals. If you choose not to listen to us now and saliva on paper this public participation. Thank you. Are there any questions? Chair, last time there were no questions presented to me, but as this is a two-way street, I actually have some questions of the legislators, if I can be accommodated.
Members, are there any questions? This time is reserved for members and the departments to ask questions, not any other person.
I just need to understand how we got to this, so surely the legislators could just give a little more clarity with some specifics.
So members, we are fine. There's no question. Thank you very much. Mr. Duplessis.
Can I ask a question?
Yes.
Okay, of Mr. Makumbete, when it comes to...
Sorry, can you raise your voice? It's difficult to really hear you.
Mr. Makumbete, when it comes to the scheduled harms of THC that's used in this bill to justify the types of criminals, what exactly was presented to you that made it seem logical, if not scientific, that one molecule could be defined in 3 different ways: public, private, medical, non-medical, religious, non-religious? And yet you have 3 different chemical effects, and in some settings, those chemical effects would require criminalizing citizens. What science was presented to you that made this logical, Mr. Makulubete?
Thank you very much. Is that a question you have?
Yes.
Thank you very much. Mr. Makulubete, would you want to answer now, or you will come when you respond to everybody who has made inputs?
Yes, Chair, thank you. I'll rather answer the question now. However, I will come back when we do the summary, when we present the summary. But for now, at least for Mr. Duplessis to keep at the back of his mind as to where we are coming from when it comes to what we have in the bill. It has been raised from yesterday and even from in the past that the Department of Justice is not responsible for the commercialization, that we are aware of. But as the department, we are responsible for the courts and the criminalization of a certain act. Right. Now, with this bill, we are responding to the direction and the order given by the Constitutional Court in the Prince judgment. I must reiterate, because that is the very basic foundation of us as the department to have this bill the way we have it now. The Constitutional Court gave an order to decriminalize the use, the possession, and cultivation of cannabis. And the way it was done by the court was to leave it open for Parliament to come up with the quantities that will be sufficient, because the Constitutional Court was specific that what can be legitimate or legalized will be the sufficient cannabis per adult. That is enough for one adult for personal consumption. Now, what we have in the bill is strictly to comply with that, to say that here are the amounts that are limited for an individual for possession and use. And these are the number of plants that we consider to be sufficient for personal consumption. And now, the Constitutional Court, if I may go back to the point that was raised there, in relation to dealing in cannabis, the court was specific that it will not decriminalize dealing in cannabis. Now, what we have done is to at least give those prescribed quantities so as to also avoid the potential of dealing in cannabis.
No,
Yes, Chair.
But if I understand Mr. Duplessis' question, he will correct me if I'm wrong. In determining those quantities, what did you rely on? I think that is his question. If I'm wrong, Mr. Duplessis, you will correct me.
I think that's how I understood it as well, Chair, but I will get straight to it. What we did was we considered various pieces of legislation from different countries. The table, we have formulated a table to determine as to how many quantities are determined by the various countries. And we have
specific question. My specific question is, how is it that this bill has ended up deriving 3 different scenarios for one molecule? And some of those scenarios end up in criminalization. That just doesn't make any scientific sense. And my question was specifically, what science informed this? That was my question, is what science informed this?
Thank you, Mr. Duplessis.
Yes, thank you, Chair. Let me get this straight to that question. As I was saying, we looked at the practices from different countries to check how do they legislate the use and possession of cannabis. And we drawn from that. We could not get a scientific determination of what will be sufficient for personal consumption or what will be sufficient plants for cultivation. We used the previously determined quantities of cannabis and cannabis plants. That's where we come from in relation to it. Various countries have determined 6, others 4, others 7, and they differ like that. And we have determined 4 plants for our country, and then
sorry, Mr. Makulubete.
Thank you, Chair.
Sorry, Mr. Makulubete. Mr. Duplessis, can you mute yourself?
Chair. I'm concerned South African science didn't.
Mr. Du Plessis, can you mute yourself? Thank you very much. Proceed, Mr. Makulubeta.
Yes, Chair. In conclusion, I was actually concluding to say that we do not have a scientific measure of determination of what will constitute a sufficient amount for personal consumption. And the quantities that we have in the bill are in accordance with what I can call practices from different countries. And then we drew from those, and then we invited comments to ask the members of the public to assist us in coming up with the sufficient numbers or quantities. And we still stuck with that. And because people are not assisting in as far as the quantities are, what quantities can be included in the bill. And now, obviously, Chair, when these, when there are limitations like we have in the bill, if those are exceeded, then there will be a contravention of the law, and then there should be penalties for that. That is what we have in the bill. Thank you, Chair.
Thank you, Honorable Masako Taylor.
Thank you, Chairperson. I think now, Chair, we are the whole thing is becoming clearer, because I just want to apologize, because when this bill was introduced to us, Chair, if you remember, it was the time when I was in the hospital during those times, so I could not get some of the documents go through properly as we normally do. So my apology to that, Chair. That's why I was requesting that maybe if one can be also given more, so that we can also, when we deliberate, go to this, one go into the details. But now what makes me also to be kind of not settled with the explanation that we get from Mr. Makulubeta is the issue that the courts said we should decriminalize this. And in decriminalizing this, they did not give us the specifics. They left this thing to Parliament. That's what, if I'm mistaken, please correct me. And secondly, Chair, here we are now. Mr. Makulubeta says he considered other countries' researches or what is happening in other countries. My concern now is that we went outside without considering the situation in South Africa. Hence, we find ourselves where we are. And if I'm not mistaken, Chair, at some point before I went to the hospital, I know that there was a presentation from SAPRA about this matter, about the THC levels and all those things. It means what we are having now, you'll correct me, Mr. Makulubeta, and the team, what we are having now, it is something that talks to Europe. Like yesterday, we got some presenters, Chair, saying to us this bill currently in its formation, it answers or it is Eurocentric. It doesn't talk to us in South Africa. So it means that if we have to twinkle or change or do whatever that we need to do from here, is it possible for Mr. Makulubeta to go and consider the South African situation in a manner speedily that is informed by the presentations that we get now? I think he understands the situation in terms of, we don't want to finish this bill that is not talking to the situation in our country, in talking to the issues that has been raised here. And we don't want to find ourselves again in front of the Constitutional Court answering also these issues of saying, instead of decriminalizing, we went back, like, if I have to take words from the presenters, to apartheid and take some of the things that makes this bill to be also not giving freedom to our people. So this is my comment, Chair, on this matter, because we have to consider all those presentations, and Mr. Makudubetse must go back and look at the situation in South Africa and talk to that situation, Chair. That is my proposal on this one. Thank you. If I'm out of order, Chair, correct me. You'll help me. Thank you, Chair.
Thank you. Mr. Makudubetse, do you want to respond? Or do you
Yes.
respond to the summary
Yes.
that you bring?
Thank you, Chair. Let me respond in full when we come back with the summary, because now we'll have to search for the documents where we have identified and tabulated different countries and their experiences. What I can say for now to Honorable Maseko Jele is that we don't have a scenario in the country in terms of how much is sufficient for personal consumption. That is why we looked outside. And it's not Eurocentric. We also looked at African countries, because we do not have those quantities in any legislation in as far as this cannabis is concerned, for the obvious reason. That is why we are here. And we are trying to come up with the quantities that will be sufficient, and then we invited comments on that. The comments are not forthcoming because the intention is to have a full-blown decriminalization of cannabis. That is without restriction. And that cannot work because we as justice cannot do that. We cannot commercialize. That is why in our bill, we're making for provision for other department for a national legislation. Could be Department of Agriculture, Trade and Industry, is the department that is going to come up with a commercialization legislation for cannabis. So people do not want restricted quantities, and we as justice cannot give open-ended quantities. That will be left for national legislation. However, Chair, in terms of the documentation, we will be able to come up with that when we come back to the committee during the briefing on the submissions and the responses by the committee. Thank you, Chair.
Thank you very much. Before we move to the next 12, I need to change gadgets. It's load shedding. Thank you. Thank you very much. You have 10 minutes.
Is the secretary going to put up my presentation?
Mr. Romano, can you assist?
No, you have the right to take it.
We can't hear you.
I'm saying I've given you permission to share the presentation.
Okay, permission has been given to you, Mr. Prince, to share the presentation.
Okay, just give me 1 second, Chair. I also had to switch. For the load shedding. Coming up. God wants you to quit it. No, it's not gonna. It's not gonna get on there. We should. That's not gonna get on. Just having a challenge here for a sec. In trying to share, I'm having difficulty sharing my screen. Is the secretary not at all able to put up the presentation?
I don't have. Did you send us a PowerPoint?
Pardon, you want it very audible, Secretary.
So I was asking, did you send us the PowerPoint presentation? Because I only have the submission that you sent via email.
Yes, I send it via email. That's what I sent.
Is it possible that, Mr. Prince, we can go to the next presenter and in the process you are able to communicate with the committee secretary?
Yeah.
Yes, if there is another presenter, Chair, by all means.
Are Doctors for Life ready to make a presentation?
I think actually I've managed to get it up. Where was they had it up? The guy had it. Or was it the secretary that had it up now? Because I saw it there.
Is that the one?
That's the one.
Okay.
I think he just, yeah. Put up the full screen.
I am starting to count now.
Yes, it's not very readable. Could the secretary perhaps put it in full screen?
It is on a full screen on my side. I don't know if others can see.
That's better. That's better, Secretary. Thank you very much.
So let's start. It's 6 minutes past 12.
Can I just state for the record that I was very heartened when I saw this portfolio committee went to bat for the South African public in relation to the Thabo Bester escape saga, and when it hauled the Minister of Justice, Minister of Police, the Judge Inspector for Correctional Services, and the National Commissioner for Correctional Services before Parliament to answer. And it made me wonder why the Commission haven't chosen to exercise that power in respect of what is happening to this bill. Because as we've heard, we've had many members of our community, or several members, died. We've had hundreds of thousands of members arrested since the 2018 judgment, and we are nowhere close towards finalizing this bill. And perhaps one would implore this commission to consider whether or not calling these executives before Parliament to answer why is it that it's taken nearly 5 years for us to complete this bill. Now, Secretary, the manner you've put it now there, I mean, I can't read on the screen here. All right, I'll just use from another read from another screen. The bill's continued insistence to separate dagga and hemp and to define and link commercial hemp activity to a concentration of THC remains problematic because primarily it doesn't honor our constitutional rights and it therefore endangers the constitutionality of the bill. It opens the amendments up to the charges of being procedurally as well as substantively defective. More importantly, in our view, the amendments does not respect, protect, promote, or advance the interest of the larger dagga community in South Africa, especially the previously disadvantaged, and therefore cannot be supported by the cannabis community. In respect of the procedural defects, there's been no public input in drafting of the amendments. Violation of the proposed amendments could lead to fines of thousands of rands or imprisonments of 6 months in terms of section 13.2 of the revised bill. This is a serious matter and it could be life-threatening to many citizens in so many ways. It certainly is something that we, the cannabis community, has an interest in. The failure to consult us meaningfully about these new amendments and its impact on us as the people is, in our view, fatal to the legality of the amendments. Simply giving us a month or 6 weeks to comment on decisions that is already been taken is not adequate. Publishing the bill in English only and relying on mostly electronic invites unduly limits the reach of the bill and effectively excludes thousands, if not millions, of people. People have a right to have a say in the making of new laws. Our law boldly protects the right of South Africans to have a participatory democracy. The people have a right and a duty to participate in the making of laws, especially those that propose to imprison or financially ruin them. Our apex court said, the more discrete and identifiable the potentially affected section of the population, the more intense the possible effect on their interest, the more reasonable it would be to expect the legislator to be astute to ensure that the potentially affected section of the population is given a reasonable opportunity to have a say. The proposed definitions of commercial hemp activity and levels of THC concentration is obviously one that is of great significance to the dagga community. Government's decision to artificially separate the dagga plant is most certainly one that the public would have liked to have input on, but Parliament neglected to hold any public hearings or to hold any workshops or information campaigns around dagga or hemp. We certainly have not been afforded a reasonable and a meaningful opportunity to raise our views. Even if Parliament's conduct is evaluated as against the attenuated or lower standard of rationality, their conduct can still not be labeled as astute. In our view, they fall dismally short of complying with the requirements stated in Parliament's own public participation model. And just perhaps on that point, the public participation model, it obliged Parliament to first inform the people, consult the people, engage the people, and then give feedback to the people. And whereas this model was adopted in 2019, we've seen that when it comes to the issue of cannabis, Parliament refused to follow their own model, and they've done very little informing or education or consultation with the cannabis community. In our view, there's been no consideration for NEMA, which is the National Environmental Management Act, and the rights of the environment. Our environment needs to be protected in an integrated manner, and just as we now have campaigns against alien or invasive plant species, we must prevent the unfettered mass infiltration of our environment by foreign cannabis varieties. It must form part of the oversight duties of Parliament to protect our local dagga strains. There is nothing that prevents dagga from becoming another champagne. And France would not just allow any brand of grapes to be planted in the region of Champagne. South Africa has a very valuable dagga brand, and it's important that the government protect this. And it is the government that we want to go to bat for the previously disadvantaged and vulnerable cannabis community when it comes to protecting the intellectual property around our indigenous landrace strains. Section 2.4 bracket A of NEMA requires sustainable development, which requires a risk-averse and a cautious approach, whereby negative impact on the environment and on people's environmental rights can be anticipated and prevented, and where they cannot be altogether prevented, they are minimized and remedied. The legislator can meet these demands by working with the full spectrum of the indigenous dagga plant, yet he chooses to accommodate and import foreign cultivars whose impact on our local varieties have not been determined. This is not a risk-averse or a cautious approach, it's a reckless one. NEMA further requires that the environment be protected by securing ecologically sustainable development and use of natural resources while promoting justifiable economic and social development. Dagga is our natural resource and capable of doing anything hemp can do. Its ecological compatibility is already established, whereas that of hemp is not. We have not yet definitively established the sustainability or environmental impact of approved hemp cultivars, yet the bill calls for them to be allowed, while it downplays the abilities of local dagga. Justifiable economic development requires that barriers to entry be minimized, whereas in our view, the latest amendments maintains and increases barriers to entering the industry. Section 2.4 bracket B of NEMA states, environmental management must be integrated, acknowledging that all elements of the environment are linked and interrelated, and it must take into account the effects of decisions on all aspects of the environment and all people in the environment by pursuing the selection of the best practical environmental option. Working with commercial dagga as opposed to commercial hemp allows the state to have an integrated, environmentally sustainable and interrelated cannabis policy. The failure on the part of the Department of Justice to call for environmental impact assessments in respect of how foreign hemp cultivars would impact land-raised strains is culpable, and it shows the perfunctory manner in which the state have treated the issue of commercial hemp. There's been no compliance in our view with Section 7.2 of Act 106/96, the Constitution of South Africa.
We are left with 2 minutes.
The section obliges all government functionaries to respect, protect, promote, and advance the right of South Africans. Legislation must also abide this obligation, and the amendments are suspect in this regard. The Constitution also obliges the government to develop laws that are interdependent, interconnected, and interrelated. And the proposed amendments are with respect anything but interrelated, interconnected, or interdependent. The definition of commercial hemp activities does not respect, protect, promote, or advance the interests of the dagga community. The licensing of the license, the financial nature of the licensing automatically excludes the majority of our community, and it's a formidable barrier to the entrance of people into this industry. Finally, I want to speak on the regulatory powers of the Minister of Justice. In our view, the regulatory powers of the minister is ultra vires, or that the bill proposed to give to the minister is ultra vires. The amendments proposed to confer on the minister broad regulatory powers, which in effect would amount to the power to amend the schedule or the main body of the act. And as the schedules are essentially part and parcel of the act, it in effect delegates original power to amend the act itself. This is a complete delegation of original legislative power to the executive, and there is no clear and binding framework proposed for the exercise of the powers in the amendments. And this is constitutionally impermissible. This could lead to the charge that the powers of the minister are ultra vires, as was the case with the regulatory powers in respect of natural health remedies or alternative remedies. It would seem that the amendments were drafted without having regard for the findings of the Apex Court in Smith versus Minister of Justice in 2020, as well as the findings in the Minister of Health and others in 2022 in the Supreme Court of Appeals. In the final premise, CDC would like to submit that the proposed amendments fall foul of constitutional obligation and has very little prospect of passing constitutional muster. And we would need to deliberate further with Parliament, and we desire to make further representations with Parliament in drafting and legislating this bill. I would appreciate any questions.
Thank you very much, Mr. Prince. Members, are there any questions to Mr. Prince? Honorable Maseko Taylor.
Thank you very much, Chair. And also thank you, Mr. Prince, for your presentation. I think, Chair, I would want to make a comment in relation to the complexity of this bill as presented to us, because Mr. Prince is also aware of that because when he started with his presentation, he indicated that we needed to summon these other departments that also talk to this bill. I think, Chair, the issue that makes this to be more complex, it is that issue of Mr. Prince that he started with by saying, sorry, we are supposed to get, I think Mr. Makurubet is also listening, in line with what has been presented. We are supposed to get also the views of those departments, but also, I don't know how, because that will have to be done as we are speaking now, because we all of us understand that this bill must be done now because of it has been long, Chair, that it should have been done in the previous dispensation. I'm saying, Chair, for this bill to get justice, let's get our own work and then, in fact, work on our a summary of these presentations. But before we close it, let's get these departments that are involved here. Because our chair is about the law. We have to respond to
Honorable
Chair.
I think we are raising issues for deliberations.
Oh.
I think now we have to ask questions to Mr. Prince.
Mr. Prince. Okay. Thank you, Chair. Let me just say to Mr. Prince, maybe my apology, Chair. Then I even saw that I'm in that space now. Mr. Prince, what from your presentation, how can we respond, assist us, make this for the department to respond speedily and in a manner that is not going to delay in responding to those issues that you have raised? What is it that we can do speedily? I'm just summarizing this, Chair, because I'm already out of order. Thank you. Thank you, Chair.
Thank you very much, Mr. Prince.
Honorable Masiko Jere, we are very glad that you are better and that you are able to give your full inputs into the portfolio committee. And we trust you get better. In respect of your question, at this stage, there are certain things that are fundamental that was done wrong from the outset. Number one was the tagging of this bill. And we've seen that there was in the previous round of deliberations that this issue was mentioned and the inputs of the parliamentary legal advisor was given. However, it would seem that the bill is still proceeding as a Section 75 bill, which is a fundamental constitutional defect, because we have seen that in the manner that the bill has changed, where it started off as saying that there's no scope for commercial activity, it now says that there has to be commercial activity. Whereas it started off as saying that this is a bill that has no impact on the provinces, or it doesn't need to pass the National House of Traditional Leaders and Kings. We now have a situation where indeed those have to be done. Now, the issue of tagging fundamentally impacts on public participation, and that has been one of the most vocal grievances in respect of this bill, the fact that there hasn't been meaningful and adequate public participation. To simply ask us to make comments on decisions that has already been taken. There are plenty decided cases in our law that says that that is not adequate and that there has to be done more. I have been at the forefront of fighting the struggle for the freedom of cannabis for the past 25 years. And never have I felt, not once, even in the past 4.5 to 5 years, have I felt that my views or my community's views are being taken serious, and that's being taken into account in the construction and development of this bill. Whereas this is a bill that could have allowed us to demonstrate to the world how we, the South African public, can work with our government in order to provide within the aims of our government, which is food, clothes, shelter, health, education, and welfare for all our people. But we missed that chance with the very narrow view that the Department of Justice have put upon this bill. And it is unfortunate. We've said in our previous submissions that the Department of Justice has fundamentally misunderstood their brief. The Constitutional Court was only obliged to find unconstitutionality on one ground. That is what the judicial policy of minimalism says. Now, lawyers will understand that. It was Parliament's duty after that to ensure that they create a bill that complies with all of the constitutional obligations that our Constitution promised unto citizens, not just for privacy. Parliament has to be comprehensive. They cannot be minimalistic like the court. And in that respect, the fact that this bill is called the Cannabis for Private Purposes Bill, that in itself is the clearest indication of the contradiction in terms that we are dealing with here. We need one bill. And in essence, in this, we don't need anything new. Cannabis must be regulated in the same manner as alcohol and tobacco. And you cannot put more restrictions on the cannabis community than you put on these other communities. So the clearest thing that needs to be done is cannabis must be removed from the responsibility of the Criminal Procedure Act, the Drugs and Drug Trafficking Act, and the Medical and Related Substances Act. These departments, they cannot have the primary oversight. Their oversight can only be secondary. In the very same way, the Department of Police or the Department of Justice doesn't regulate alcohol and tobacco. That's something that is part there for the food industry. It falls under the Department of Trade and Industry. So that has been our concern right from the start. We are not against regulations, but what we are saying is that international law, all of that tells us that the issue of cannabis is not an issue for the criminal justice system. It's not an issue for the police. It is a socio-economic issue. And the equality laws demands that the cannabis community not be treated worse than the alcohol or the tobacco community. So the Department of Justice, they need to remove themselves, well, from the primary oversight. They can have secondary oversight like they have in relation to alcohol and tobacco, but they cannot subject the cannabis community to stricter regulatory controls than they do alcohol and tobacco, because that is a fundamental equality and dignity as well as freedom issue. Because if you arrest me, you automatically implicate my equality rights, my dignity rights, as well as my freedom rights, as well as a slew of plenty other rights. And we, the cannabis community, do not deserve that. And can I just end up by saying, we now have a cannabis master plan. There's no master plan for alcohol or tobacco. Cannabis presents South Africa with the most realistic opportunity of putting our millions of unemployed people to jobs, of restoring the dignity of South African citizens, of freeing up from the prisons and the correctional services, those people that are preventing the Department of Correctional Services from fulfilling their mandate. The police have got other things that they need to focus their minds on. And we, the cannabis community, we cannot have an economic plan for cannabis, but then on the other hand, we also have apartheid-style, draconian regulations that wants to lock us up for growing plants. As I've said earlier before, people should be commended for growing plants, and the government should encourage South Africans to grow as many plants as possible. That is part of what environmental justice is, and we should regulate not in the field, but regulate at the end. We should regulate not the production in the field, but when the cannabis is processed. So we should regulate at the level of processing, not at the level of production, and allow the plant to be treated as a plant that has the ability to restore environmental integrity, and a plant that has the ability to assist the South African people in restoring their own dignity. And that is why we want to work with our parliament, and we have not been afforded the opportunity to do that.
Thank you very much, Mr. Prince. Any further questions? Dr. Lutz, are you there?
Yes, Chair, I am here. Apologies if my network is a bit unstable, load shedding. Chair, would you like me to respond to the tagging issue?
Yes.
Thank you, Chair. Chair, the committee will recall that I did an opinion on tagging, and we highlighted where the impact of a change of tagging to from 75 to 76 will be. That impacts in how a committee engages with the public falls in the NCOP phase. So where we are allowed to comment on a change in tagging when it comes to the NA phase is between when a committee has decided on what it would put in the A list and before the second reading in the NA. So at that stage, when we know what the committee's decision is of what it will be recommending in the A list as changes, we can assess the impact and then at that stage advise the JTM as to a possible change, because that change will have to be effected before the second reading and before it is sent to the NCOP for processing, so that that house knows how to process the bill in terms of public participation. At this stage, Chair, also perhaps just to point out that nothing that the issues that are put in now are not decisions of the committee yet. These are proposals that the committee are considering for possible inclusion. So that's why we can't make a tagging change recommendation at this stage, because we have no definitive document that sets out that these are the decisions of the committee. That would be the A list that the committee will be considering. So these issues of hemp and commercialization and all that, these are possibilities that is being put to the public for input so that the committee can take that input into consideration in making a decision, whether it should stay, if it should stay, how it should be formulated, and then that will feed into the A list. That A list will feed into a possible tagging opinion, and that tagging opinion, if it changes, will then change to a 76 before the second reading and indicate to the NCOP how to process. I hope that clarifies it, Chair. Thank you.
Thank you very much. Mr. Makulubete?
Thank you, Chair. I do stand by the address by Dr. Lutz in as far as the taking of the bill is concerned, because at this stage, the Parliament still has to make a decision and a final conclusion as to the acceptance of the amendments that have been proposed on the bill when it was initially introduced to Parliament. So I do stand by this decision, the submission by Dr. Lewis. Thank you, Chair.
Thank you very much. I see, Honorable Nsego Jele.
Thank you, Chair. I still want to hear the comment of Mr. Roots in terms of what Mr. Priest said, except the issue of tagging, if it's possible, both of them, Chair. I just want to hear them. What are they saying? Thank you, Chair.
I'm not sure about Dr. Roots, but let me hear from her.
Chair, at this stage, all that I can say is that if we come to a stage where the committee has decided that it wants a commercialization type of clause, or that speaks to that in a way that falls within the ambit of the bill, we will then assess whether that, the wording of that clause, because even a comma can change a meaning in a clause, whether that clause has an impact that falls within an area of competency in commercialization that deals with a 76 issue. And that then will trigger whether we can advise whether it's a 76 or not. At this stage, I am hesitant to make such a call because I can't do an impact assessment in that way as yet. So the possibility is there, that I can say, but I can't say for sure whether it will be. That's as far as I can take the argument at present, Chair. Thank you.
Thank you, Mr. Makulubete.
Yes, thank you, Chair. The department will still have the opportunity to do the briefing on the summaries that we have, on the comments that we have received, together with the summary of our responses thereto. And not only will that relate to the written submissions that we have received, but also in addition to the presentations that we have had, further arguments and the further clarification of the issues that have been contained in the written submission. So it will not be an appropriate time, Chair, to respond to those at this stage, because we also have to consider the whether other submissions do relate to this bill. For instance, the NEMA, whether NEMA does apply to this bill or it does apply to a bill that we are saying should be promoted in terms of the commercialization. So we are not in a position to respond succinctly to those at this stage, and we will need time to have a look at those together with the submissions that we have had from yesterday and today, Chair. Thank you.
Thank you very much. Who's old Mac?
That is me, Honorable Chair. I just needed a follow-up on a comment that that Dr. Lutz made.
Okay, please proceed.
So in the event that, let's say theoretically, that Parliament decides that this should have been a Section 76 bill, does that mean that the National Assembly would then be able to pass that onto the NCOP? Because the law says that if the National Assembly failed in their responsibilities, then Parliament as a whole has failed. So the fact that the NCOP might be able to deal with the bill as a Section 76 bill doesn't excuse the fact that the National Assembly failed to deal with the bill in terms of a Section 76 bill. Or does that in effect mean that the National Assembly would have to start afresh in the event that indeed a Section 76 tagging is made?
Thank you very much, Dr. Lutz.
Thank you, Chair. Chair, if you compare sections 75 to 76, at the point where it goes to the NCOP, everything at this stage is the same. So whether we were running with a 76 bill or whether we were running with a 75 bill, the NCOP would not have approached it differently. The changes come after at that shift where we go to the second reading. And if I can also just refer the members to Section 57 of the Constitution, which gives Parliament the powers to regulate its own internal processes and procedures and put in place rules. Parliament's rules allow for a change of tagging at certain intervals. And one of those intervals, when it comes to when there is something that changed, because the bill when it was introduced was a 75. We're sitting with a situation where the committee is currently considering options that could potentially change its impact to a 76. And those rules now, in line with that power that Section 57 of the Constitution gives, allows Parliament's tagging mechanism to change the tagging once it becomes aware of the fact that a portfolio committee is on the point in the A list of recommending changes that would alter the scope of the bill to impact on an area of consequence that affects the sections or that triggers the Section 76 process. And that's when it shifts. There's nothing unconstitutional in that shift, because if you look at the two processes, 75 and 76 together, they run parallel up until that point when it comes to the NCOP process. Thereafter, it splits. And then with referrals back to the PC, it would change. If it's a 76, if the select committee then makes changes, that would come back to the portfolio committee in a different alteration than it would if it was a 75, where it would merely be recommendations. The NCOP's input would carry more weight, but that comes after that process. So up until before the second reading, we are still, in terms of the rules and in terms of the Constitution, allowed to change that tagging. And nothing will have negatively impacted on the process. And nothing will have to be redone in terms of how we approached it, because the public participation at this point is almost, if I want to say, a one-on-one type of situation, where if it goes to the NCOP as a Section 75, it becomes a provincial vote that comes into consideration, and each province will have their own public participation mechanisms that kick into gear. But up until this stage, Chair, I feel that we are sound in the fact that we are in a realm now where we still have possibilities and options. And this is the key point in which this should be carefully weighed, carefully considered, the wording, and then we make that determination, if required, in an opinion to the JTM for consideration. Thank you, Chair.
Thank you. Thank you very much, Mr. Prince, for the presentation and for the engagement. I think we can now move to the next presentation. Doctors for
I am
Life.
here for Doctors for Life.
Thank you very much.
Is there a possibility that I could share my screen, please?
The committee secretary will assist you.
Yes, please go ahead.
Okay, this just tells you that I am here for about this hemp legislation thing, and that I am a specialist physician and have practiced medicine for quite a number of years, as I think you could have seen. Now, let me just fall in, and I need to speak about some definitions that have been floating around here, and have been. The first is that it was said that there isn't information about road accidents. There is information about road accidents that came about after the legislation in the United States and other countries was passed legalizing cannabis. I was not part of the brief and will lengthen my, it was not part of the brief, and it will lengthen my presentation beyond 10 minutes if I have to speak about road accidents. So none of my content actually addresses human rights, the Constitution, or law. It addresses medical science and medical science alone. And for this reason, I would just want to hone in onto some definition. The first is that what are pharmaceutical products? Pharmaceutical products are refined with a fixed, defined, purified content, and extra molecules are not acceptable in such products, so that we know exactly what we're dealing with. All pharmaceutical products have been subjected to stringent, double-blind, randomized trials, which means that neither the doctor nor the patient knows what they've been administered. And these are randomized, which means that they are not necessarily case-by-case alternated, but randomized so that no one can work out which patient is on which drug. It is approved by ethical committee per site, which means that if 30,000 people are enrolled into a study like this, there are 300 ethical committees involved, and therefore these cannot be corrupted. It is done under what we know good clinical practice conditions, and physicians who do research have to be trained in this and have to have a certificate. There are many preceding phases to ensure maximum safety to patients, and CBD refined with no additional THC is indicated only for rare cases of childhood epilepsy. And pharmaceutical value is determined by the regulatory authority, so that only pure CBD is accepted, and that is produced by a company who actually can refine to that level. So there is no medical use for a CBD oil, and no doctor will use it, and it actually causes some problems in interactions. Now, as far as other places where this has been legalized, in 2018 in the USA, there was a Farm Act that made hemp legal, and it was grown commercially. The delta-9 tetrahydrocannabinol, or delta-9 THC level, had to be less than 0.3% by law, and people have actually honed in on how impossible it is to keep this, because there's no guarantee that the plants will remain in those limits. The enactment of this legislation caused ambiguity that was exploited by businesses who engaged in the sale of delta-8 tetrahydrocannabinol, which has, it's an isomer of delta-9 cannabinol, which is the active component that is used for religious and other effects. And it has not been evaluated by the American Food and Drug Administration for human use at all. But it is a side product of the so-called hemp when the CBD is extracted. Now, some manufacturers have used unsafe household chemicals to produce the CBD oil, and this raises concern around CBD and CBD oil from hemp. Delta H tetrahydrocannabinol has not been approved by the South African Health Products Regulatory Authority or SAPRA at all. But the human effect is comparable to Delta 9 THC, but it seems to be slightly less active. Concentrated amounts of Delta THC can be produced from hemp-derived cannabidiol. And Delta H-THC is a psychoactive substance with similar effects as Delta 9 THC. And this is of great concern due to the addictive value, but also the central nervous system effects that occur as a result of it. The American National Poison Control Centers between January the 1st, 2021 and February 28th, 2022 had 2,362 documented exposure cases of Delta 8 THC, and 8% of these patients were admitted to critical care, to intensive care, in other words. One pediatric patient died. And then the other thing is that Delta H THC is schizophrenogenic, which means that long-term use can lead to the arising of schizophrenia, which is one of the most severe psychiatric conditions that can arise. 2 patients were admitted to ICU after ingestion of candies, and these were gummies or sweets that the patients had. One of these patients had to be intubated and ventilated, and the other one was exposed to other modalities of non-invasive ventilation, because in high doses, the Delta 8 and also Delta 9 THC can suppress ventilation. The FDA has not evaluated Delta H THC yet, and it received adverse event reports for Delta H THC containing products, and many United States have banned Delta 8 THC, even those who have legalized and commercialized cannabis. It has both psychoactive and intoxicating effects, and potentially harmful chemicals are used to produce the Delta H THC, as I said before, to attain the high concentration of Delta H THC, which is actually expected in the marketplace. The FDA received 104 adverse event reports for Delta H THC in that period over time. 77% involved adults, 8% pediatric patients under the age of 18, and 15% were unspecified. 55% of these cases warranted intervention, in other words, evaluation by emergency medical service or a hospital admission. 66 were food products related, and these were gummies containing Delta H THC, brownies, gummies, and vaping products. And these products are already illegally sold in South Africa at kiosks in shopping centers, which is of concern because obviously the brownies, the gummies are eaten by children and has caused quite a bit of problems there. The adverse events caused included hallucinations, vomiting, tremor, which is shaking, anxiety, dizziness, confusion, and loss of consciousness in high doses. Now, the American National Poison Control Centers, which is another authority that receives reports, received 2,362 reports, 58% adults, 41% children, under 18 years, and 1% did not report age. 40% of these were unintentional exposures, and 82% of the unintentional exposures were in pediatric patients, in children, in other words. 70% required evaluation, 8% were admitted to critical care, 45% of these were children, and 1 child died as a result of this. So it is not completely innocuous, but obviously it was in high doses, and it was when children ate many of these gummies and the chocolate chip cookies. In specific people, it can become schizophrenogenic, meaning that the people can become schizophrenic, mirroring the effect of delta-9 THC, and causing it has caused a major increase in motor vehicle accidents and in deaths, where delta-9 THC was
You are left with 2 minutes.
Was legalized for thank you for that, Mr. Chairman, was legalized for private use, primarily in the ICU, and now then there has been some mouse research which has actually said the same. And I would just like to show a specific some graphs. So there are bar graphs that have shown some specific problems. And here is a bar graph of Colorado traffic fatalities. The line indicates when the cannabis was legalized, and there was a surge of accidents thereafter. The black tops of the graph show that the people in which cannabis was present in the blood of these patients, and there was an increase in these accidents. And as you can see, traffic fatalities increased over 31% since 2013, when the legalization took place. Okay, I will stop my presentation there.
Okay, thank you very much, Dr. Celia. Are there any questions? Honorable Maseko Jele, followed by
Thank you very
much.
Okay. Thank you, Chair. Chair, thank you very much, Doctor, for your presentation. And Chair, I'm noting that this presentation, it gives us a research from overseas. It does not talk to us as the South Africans here, our situation, which also brings me back to the comment that I made last time that there was such a presentation from SAPRA when at the beginning of this. So my question to Doctor is that, would you agree with the presenters when they say they don't have a problem with regulating regulation in terms of this, but that whatever regulation that will be coming up with, it should be at the use end, not at production? In consideration with South Africa is the developing country and Africa as a whole. And people of South Africa are still in the business of developing themselves in terms of business and in terms of growth, in terms of also experimenting what they have in order to showcase to the world. So if we use your presentation in informing the bill that we have now, is it not impacting on that perspective that South Africa is a growing nation and we can't just come and come up with some laws such as these ones research is talking about in regulating in fact, in informing this bill. Thank you, Chair.
Thank you. Honorable Nevo Trojan.
Thank you, Chairperson. Good afternoon to everyone on the platform. Thank you, Doctors for Life, for your presentation. I have a few questions for Doctors for Life. Earlier, the presentation said, or they were saying that Doctors for Life was the only one who differed from all the other presentations. And I wanted to focus on that. When I read through your submission, I see a lot of schedules, but I only saw now that most of the research was done in America. So I wanted to ask Doctors for Life, did you do any research here in South Africa? For example, the road accidents. Most of them are based from America, but earlier presentations said that accidents due to the use of cannabis, it's not high here. Alcohol, yes, but not cannabis. So, and you differ from this. So that is why I wanted to know whether you've done any research in South Africa, and if so, what it was. Then secondly, I wanted to know the plant, when you know the plant that is grown here, is that the same as the plants grown in America? I mean, I don't know. That is why I wanted to know why you wanted to compare America to South Africa. If the question with regards to the plants that are grown here, if it's not the same, if it's the same as the American plant. Most of the departments, I'm assuming the department got their research from Europe and not America. So now what does your presentation say with regard to the plant itself? And then most of the presenters today and yesterday, especially with the Rastafari community, has the Doctors for Life ever engaged with the Rastafari community, whether in America or in South Africa? Because many Rastafari users of cannabis, they use it for religious, cultural events. Have you ever discussed anything like this with them at all? Were you ever in consultation with them? And then what you explained with regard to the numbers of THC, the Delta 8, and those numbers, is it the same as in South Africa?
Okay.
On the website, you also say that, and then does it apply to South Africa as well? Thank you, Chair. That's my question.
Thank you very much, Dr. Nevo Trojan. Over to you, Doctor.
Is that over to me now?
Yes.
Okay, the first thing is, as far as the use in developing countries is concerned, let me state categorically, there is no difference between South African people and American people. So as far as the effect on people is concerned, we have to take the research from where it comes. It's not going to be different for South Africans. What is going to be different is our plant, and I'll come down to that. There, as far as the non-human consumption products are concerned, they're clearly, these are not being put into people, so that has no there is no problem with me whatsoever. Then as far as the road accidents are concerned, if you look carefully, you'll see this is the increase that took place after legislation of the drug. So that this has simply not happened in South Africa. So we don't see that increase yet, but there is some information about cannabis in accidents in South Africa. It is not actively policed or tested. So there is no way that we can find out where that is. Now, as far as that is concerned, then there are no South African figures that will accurately tell us what happens, because you need rather large usage before you can see a 4 or a 6% increase in fatalities, and before you can see a 35% increase in road accidents. And these are actually, I have condensed things, but in a lot of these cases, there actually was blood testing. Blood testing took place, and blood testing did show that it was involved in a large proportion of accidents. But the more drugs a person took, the more severe it was. In people who were injured, one drug is something like 75%, and then the percentage goes up with 2, 3, and 4 drugs used by the driver. The amount of injury to the driver increases up to 100%. So that would make no difference between countries. As far as the plant is concerned, the SA plant South African plant is known for the fact that we have the plants that have the highest THC levels in the world. And it also is well known that people do not want hemp in their cannabis plantations at all, because it decreases it actually genetically changes the plants so that the THC level is decreased when it lands in a plantation. I also cannot see how that really can be policed. So that then tells why we would then do that. There is no reason from a medical point of view to consult with the Rastafarians about their use, because the use on people is one effect and it is universal on all people. So our problem with the use of cannabis is that if you ingest it, it concentrates in fat and in fat cells. But what has not been said, that it also concentrates in the fat, in the so-called myelin sheaths that actually coat all of the nerves in the body. And that coating means that the effect on the central nervous system is different and cannot be directly related to blood levels, as has been said. But if there is a chronic use, there is a chronic accumulation of cannabis in the fibers in the brain, there is going to be much more effect on the ability to drive than if there is an acute exposure in someone. In other words, someone uses cannabis and he smokes it once, it is going to disappear. Obviously, the drug levels have nothing to do with the brain levels and the effect that it has in the brain at all. So I hope that this addresses your question. I see there's something about delta THC that I've just forgotten the specific question, but delta THC is something that develops in the manufacture of the CBD oil. But just to make it very clear, CBD oil is not medicine. It is not registered. It is not within the monthly index of medical specialties. And it creates major problems within medicine with interactions with drugs, because it has an effect on the so-called cytochrome B450 system in the liver, and it affects the metabolism of other drugs. It can either enhance the metabolism or make it slower, so that it can either make the effect of regular medicine less than it was or more than it was, but that is only for cytochrome P450 regulated drugs. And I'm sorry that I have to go through this so fast, but this is the only way that I have of answering the questions in this limited space of time.
Thank you very much, Doctor. I have two hands. I think as follow-ups is Honorable Maseko Jele and Honorable Nebot Trohan, in that order.
Thank you, Chair. I just want to find out from Doctor the purpose of him to bring this presentation to us. Was it to motivate for the THC levels, or maybe was here to maybe to give us information in terms of what is happening in America. I can't get it proper exactly what was the purpose of this chair from him in terms of motivation, motivating in terms of the work that we are doing here on this bill in assisting the bill. I just want to find out.
Honourable Person, I just want to make it very clear that there is no research in South Africa. This research is extremely difficult to do. And the reason that I take the international literature is the effect on people of drugs is the same wherever you live. So it does not matter whether you're South African or Australian or wherever you live. And the concentration of the drug, the higher it is, the bigger the effect it has. Now, as far as the whole issue of hemp is concerned, that is going to be very difficult to police as far as we're concerned. But we just want to point out that when CBD oil is created, that there is a certain, there are chemical changes that take place that produce delta 8 THC and delta 9 THC. And this will happen wherever the same processes are followed, and it is not limited to South Africa. We wanted to talk about the effect on humans of these substances, and this has nothing to do with anything else than to say this is what the science is of the effect on humans, and it does not. It is not different in South Africa than it is anywhere else in the world, because it's the effect on humans. I'm not speaking about the plant at all, but just to say that in South Africa, the levels in plants are generally quite a bit higher than they are in the others, as we've also seen from presentations before mine, and it has been made quite clear that that is the fact.
Honorable Nubo.
Thank you, Chairperson. Just one more question that I forgot. I wanted to know from Dr. Polai whether they support or don't support cannabis for medical use, especially with regards to cancer patients. I remember one of our MPs from the IFP passed away, and he lobbied greatly for the use of cannabis for medical reasons. So I just wanted to see what your view was with regard to that.
I worked in a cancer chemotherapy in a hematology unit at one stage. And in that unit, it was a major problem because of the effect that cannabis oil has on enzymes in the liver, and it changes our therapy in a way that has not been studied anywhere in the world, because nobody in the world in medicine uses cannabis or cannabis oil for medical reasons. There is no medical use for cannabis oil at all. There is no medical literature on it.
Honorable Masagwa Jele, is that an old hand or a new hand?
It's a new hand, Chair. I still don't get Dr. view on the issue of, he indicated that the plant that is in America and the one that is in South Africa are not the same. And he says now it doesn't matter whether we are all human beings. But I'm worried because I want to understand the impact that is caused by the plant in America and the plant in South Africa. So there is no research, according to him, for the plant in South Africa, but he uses the research that is coming from America to a very different situation where there is no research that has been done before, and he wants us to accept it. That's the question that I would want to have from him, Chair, to give to him. Thank you, Chair.
Medical textbooks internationally use the same information. The influence on people is the same, irrespective of race, irrespective of size, irrespective of everything. Therefore, the effect on humans is the same. If we speak about the plant, it is quite clear that in South Africa, it is not going to take very long for the hemp plant that is in America that already causes some problems via the CBD oil, that that hemp plant is going to start mutating or start producing higher levels of CBD, of delta 9 THC and delta H THC, and therefore the effect on human beings is going to be bigger. Just simply because we know that the levels are bigger, but there is no medical research that will tell you much about this. The medical research on the use of cannabis comes out of the West and out of America at this stage. There is no such research in South Africa to hone in on to, and therefore, and in any case, we would trust on the international research. We use all our medicine in South Africa based on international research. Research is done in a multiplicity of countries, on a multiplicity of people, and then applied internationally to all populations. It is not South Africa specific.
Thank you very much. Are there any further inputs, questions, or comments? None. Thank you very much, Doctor, for your input and for taking time to make a contribution during these public hearings. Thank you very much.
Thank you, Honorable Chairman. Thank you, Honorable Committee, for allowing me to talk.
Thank you very much. Members, we have come to the end of our public hearings on the cannabis bill. The department will respond to the issues raised on the 31st of May, which would be next week, Wednesday. Then thereafter, we will start to deliberate on the bill. After that, depending on the decisions that we take or the decision that we make, it will guide us as to by when, whether it will be possible also for the bill to serve before the National Assembly this term, depending on how far do we progress. But thank you very much for all the people who took time to make presentations and to do research. It was very much helpful to get to some extent some different viewpoints. That what enhances our democracy. Thank you very much. Members, we will meet on Friday. Committee Secretary, you said, what is the venue? What will be the venue on Friday?
The venue is M46 in Max Building.
M46 in Max Building. Mr. Makulubete, your hand is up.
Yes, thank you, Chair, and my apologies for distracting. Chair, I'm aware that we are back to the committee next week, the 31st, with the summary and the responses of the comments. Chair, I was wondering if the committee is not able to indulge us, maybe then to call us on Friday instead of Wednesday, in light of the hearings. Many things have come up from the hearings that we have noted from yesterday and today, Chair, to an extent that, Chair, I will not, I believe I will not be in a position to finalize everything and get the approvals from the seniors and do the presentation on Wednesday. I was wondering if the committee is not able to indulge us on that aspect.
Committee Secretary, can you flight the program? I'm trying to get the program. Can you flight the next week's program?
Oh, okay, just give me a second.
Sure.
And in the meantime, Chair, whilst we are waiting for the committee secretary, you recall that yesterday, at the meeting yesterday, Chair, we have heard that or the committee will have heard that my colleague, Mr. Dupree, has been assigned to join the team on this bill, because our colleague, Mr. Cyril Roberts, who was heading this project, is currently unavailable due to ill health. And we are hoping we're wishing a speedy recovery for him, so that he can also be on board in terms of finalizing those responses, as he's being in the forefront to the whole project. Thank you, Chair. I'll wait to find out if the committee is able to indulge us on that. Thank you.
Thank you very much. We also on our side would like to wish Mr. Roberts a speedy recovery. He is a valuable member of the drafting team. We wish him a speedy recovery. So the 31st is Wednesday. So you say you want to come on the 2nd of June. So Committee Secretary, then what will happen on the 31st?
Chair, can we come back to you on that one? We still have to discuss and then maybe come up with a proposal.
Okay. But committee members, can we agree to indulge the department to come on the 2nd? Because there'll be no point for them to bring something that is half-baked.
No problem, Chair. We can move them.
Thank you very much. Can you scroll down? Can you scroll down, Committee Secretary? Scroll down. Okay, no, it's fine. Maybe we will use that day for members to attend to other committees, or to also read up on the issues that have come up, and to visit the documents that were given to us during the first and the second presentations of our public hearings, before we engage with the department on the 2nd, which means we will be debating on the 30th, we'll be debating the budget vote. On the 31st, there would be so far no meeting on our side. Thank you very much. The meeting is adjourned.